can you, so do I have control over you?
Yes, sir.
Okay, go, next. So if it hopefully makes more sense of my opening, we prepared a timeline to direct chronologically what we believe we presented, and obviously will be explored further in much greater detail by testimony on the points in context, both by claimants' witnesses and respondents' witnesses. I do not intend to provide the level of detail and quotes, but for a brief few indications of portions of documents and portions of testimony. I leave out, obviously, much detail, and I say that up front. I'm not suggesting that this opening is a comprehensive analysis of all the documents on these topics or all the contents of the documents we point to. We are trying to provide an overview and direction of the cases we see it, and we believe we presented it, and will obviously defend it over the course of the next 2 weeks in these hearings. The relationship, the claimants here and the acts and issues that give rise to the claims by the claimants all center unquestionably around Mr. Marshall's activities in becoming an investor in Rwanda, in the mining industry, specifically in Rwanda. And he brought with him other U.S. investors. And how it came to be that Mr. Marshall was in a position to identify an opportunity to invest in this industry starts actually with who Mr. Marshall is and what his relationship with Rwanda was prior to making this investment. He was not a commercial miner that was looking around the world for various opportunities and simply at arm's length passed in an application for concessions. Mr. Marshall first developed a relationship, a trusted relationship, where he acted as both legal advisor and general consultant on business to important institutions and individuals within the Rwandan government. This relationship goes all the way back to December 2004. Mr. Marshall, at the time in his career, he was an international transactional attorney practicing in Eastern Europe. He started in the United States and moved to Eastern Europe and was practicing. He was providing advice to international companies and to nation states, sovereign entities. And he developed a specialty and had relationships with a number of governments, countries, agencies within governments, and companies doing business with them. That's how he became introduced to and started a relationship with Rwanda. Next slide. In December of 2004, Mr. Marshall and his partner at the time, providing these legal services and other transactional advice and consulting, signed an agreement to provide such services to the Rwanda Investment and Export Promotion Agency. And it's a very high level agreement because it's not specific as to projects, but agrees and set the basis for what turned out to be a very long-term relationship. And as you can see from this is, as we bring up some documents, the specific document numbers that are referenced on the documents correspond with the document in the hearing bundle. I will try to remember them and point them out, but the PowerPoint presentation has been provided, so all of these documents or snippets from documents can be traced back or found based on the individual slides. They have the document numbers on them. So Claimant's Exhibit 122 will show that it's a very high-level document. And what Mr. Marshall and his partner did, and over time it became primarily, Mr. Marshall, who developed this relationship and continued working on it, they provided these services on a pro bono basis. Given the nature of Rwanda's early stages of privatization and getting involved in international transactions, it was not in a position to pay for some of the types of legal services and other needs that it had that other nation states did. And Mr. Marshall began working with them with that knowledge and understanding. And it became, over time, a very close relationship. And when I say it's long-term, this relationship, the role of trusted legal and business advisor to elements within the Rwandan government, other institutions, over time, it became far more centered on the military and its transactional arm, lasted until 2016, until the events that really ended Mr. Marshall's investment in Rwanda. He worked for them in this role throughout all the events we see here, all the events we're going to deal with here as an investor. And it's important, and we point this out now at the beginning in this opening, because keeping in mind the way Mr. Marshall's claims, even the basic representations about things that were provided to him in writing, the accusations back about fraud, manipulation, lying, distortion, trying to get something from the government, the way he's been handled, not as a good faith dispute, a disagreement about a contract or its rights, disagreements about what happened on the ground that could happen between anybody, but accusing him of actively manipulating and lying throughout. It's coming from a government that was using Mr. Marshall this entire time as a spokesperson, as a representative, as a liaison to other governments, as someone who would handle not only specific transactions, but big picture developing relationships that Rwanda felt was important in Eastern Europe for them. They relied on him in that role until 2016. So hearing now, there's the approach they take and the accusations leveled at Mr. Marshall, it should always be remembered at the time and in context. How did they actually view Mr. Marshall? How did they actually treat him? Like a liar and someone not to be trusted? Or like someone who they trusted so much they could use as their voice and their representative with others? Through this relationship and Mr. Marshall's work and understanding about the different types of transactions that Rwanda was looking to get involved in, and his own specialty in working in similar capacities on similar transactions, I should say, excuse me, in other countries, specifically in Eastern Europe, Mr. Marshall was introduced to and learned about the privatization efforts, and at one point it focused on the mines, on mining concessions, that Rwanda was interested in getting foreign investment. Specifically, through Mr. Marshall, they were hoped U.S. investment, interested in getting in early and helping privatize, build out Rwandan mines in the mining industry. And Mr. Marshall was introduced to this early in his relationship, and by December 12, 2006, there was discussion about what it would look like if he was interested, if he did express interest in trying to put together an investment group to get involved, what the steps would be. And December 12, 2006, one of the communications from RIBA, I want to point out here, because again, I do this because in terms of the communications, not by any stretch was this the only one. By any stretch, by no stretch are we saying this email is the agreement on something. There's numerous discussions and conversations, but we point this out because we think it's indicative of the way business was actually done, how things were actually handled. Again, we think it's completely out of context and completely distorted once it gets into the legal realm that we have now, and we have lawyer positions and legal analysis and reasoning about what documents should mean and what things must have been intended or not because of the language. And what I'm trying to draw the court's attention to with this email is, how is business actually done? When Mr. Marshall was trying to get involved and later did get involved, and he was dealing with representatives of Rwanda and the ministry that was handling the privatization of mines, how are they actually handling their own written policies and procedures? Well, we see right here. In December 12, 2006, Mr. Marshall was told quite explicitly, you do not have to go through REPA or the privatization system or scheme that was in place, early as it was, loose as it was, in terms of the written programs. Don't worry about that, they say. Just write a letter explaining your interest, and we're working with you. And that informality, that trust us, this is how we're going to do it. Don't worry too much about what things say. Let's get involved. Let's get you going and get to an agreement on how we're going to do it. Working together cooperatively was how things were handled from the very beginning. So to suggest now, all these years later, when things did not turn out right and Mr. Marshall asserts a claim, that it was completely unreasonable to expect what he was told meant anything given what was in writing, it wasn't. It wasn't unreasonable because he was always assured, and he knew from his experience how things were done. Business was actually done through the personal relationships and working cooperatively. From the get-go, they assured him, that's how we do things. To draw your attention, I'm sorry, this turns out to be a lot smaller on my screen, and I'm hunching over. I don't mean to do that, but I don't know how to enlarge it. When I say the cooperative nature of the relationship, I just want to draw the tribunal's attention to the last line. In submitting plans and submitting proposals and analysis of what he's going to do, it was made quite clear to them. The Rwandan government was going to be working with him to come up with satisfactory documentation and proposals. They were going to assist in his presentations because they wanted to be successful. It was not handled the way we're now hearing it and presented, where you submit something, we'll judge it, and that's all. Instead, it was always a matter of, you help me by telling me what you need, we'll see if we can do it and how we can do it. And that was true from the very beginning. Next slide. NRD received its contract for mining concessions in November 24, 2006. Next slide. And that NRD initial award, the initial license, is at Claimant's Exhibit 17. And the only thing I'd like to point out and remind the tribunal at this point is the initial agreement from its initial investment, NRD, NRD's then owners and investors in NRD acquired the rights to 5 mines, Rutsiro, Mara, Sabaya, and Gasai. 4 of the mining concessions were in the Western provinces. 1, Nemba, was not. And the reason I just point that out is, in putting in context, as the hearings go on, you'll hear about the way things were done, at sometimes only focusing on the Western provinces and only things that affected those mining concessions. So I just wanted to point out that 4 of NRD's 5 concessions were located there. Next slide. In November of 2010, Mr. Marshall, who was not with NRD previously, was not one of the initial investors in NRD, became involved, became an investor. And if I could just take a step back, up until this point, or prior to the investment by BVG in NRD. Mr. Marshall's initial investment, when he did move forward with RIEPA conversations and ultimately applied for a concession, it was for a mining concession called the Cicero. That is not a concession that's at issue in this case, in the sense that there's no claims asserted about the fact that Mr. Marshall does not have long-term, Mr. Marshall's companies do not have long-term concessions there, but it's admitted that they don't. And things did not work out at the Cicero, and Mr. Marshall's company, his investment company, through which he and other American investors put their initial roots, if you will, into the investment that later became the groundwork for the investment in NRD going forward. They initially put that into the Cicero, and they were over time unable, based on essentially bad relationships and bad performance of relationships and who they relied on, disputes about what happened, left them in quite a hole, quite a bind there. And when the Cicero was taken from them, Mr. Marshall, already facing problems with that investment, made the decision not to fight about the Cicero, not to argue about whether he had rights to continue, but to walk away and to reinvest in other concessions that he knew became available. The NRD owner, originally, when the concessions were awarded, Stark Company, a German company, wanted out of Rwanda. Mr. Marshall and others became aware of their interest in transferring their investment, transferring NRD. And Mr. Marshall acquired that Stark interest in a private transaction. They acquired the Stark investment in NRD through Spalena, a investment vehicle that was set up simply to address the fact that the Bayview Group was no longer recognized and listed in Rwanda as a company registered to do business there. So acquiring NRD in Bayview Group's name was not in compliance with Rwandan law, and Bayview put its money through a new investment vehicle that Mr. Marshall and his other investors formed, an affiliate that they controlled.
Could I just intervene? Is there any evidence in relation to the fact that Bayview was not permitted under Rwandan law to take over the business?
To make the acquisition
I understood,
of the shares.
I understood the claimant's case to be that Mr. Marshall had no idea why this was.
He had no idea why Rwanda stood its ground and insisted that Bayview Group could not renew its registration. And it's in Mr. Marshall's testimony, and I don't recall, it's a very fair question, and I have to say I don't specifically recall if it was also addressed by Olivier Ramaswamy. Because I don't recall it, I can't say that he also addressed it, but there was a period of time when Rwanda undertook to require the foreign corporations doing business there all to renew their registrations. And he was told no for Bayview Group. That he doesn't understand. Why Bayview Group needed to put its money into another affiliated entity with a different name to then buy ownership and control of NRD's parent from Stark, he does understand, because it simply needed to be a vehicle, a company that was on the books in Rwanda. So it was an affiliate with no distinction between the investors, the managers, or the money. The money was the same money that BVG, first of all, much of the investment that was already put into Bisesero was transferred, the assets were transferred. And the monetary commitment that was going in directly from BVG then became a monetary commitment and investment going from BVG through its affiliated controlled company, Spalena, into the parent company of NRD and then directly to NRD once they owned the shares. So he understands why he put the money in the way he did. He's never been given an explanation for why it mattered, because there's no question, none's been raised, and there certainly is no question based on Mr. Marshall's presentation that this was not done behind the backs of anybody at Rwanda. Nobody, Mr. Marshall was not blocked. His investors that he had behind him were not blocked. They were not, this was not a group of individuals who knew Rwanda did not permit them to invest in the country, invest in the mining businesses themselves directly, or more specifically. They weren't getting around anything there. They were getting around a roadblock of the name that they had to put the money in. They did that by opening up an empty shell, so to speak, additional company, and putting their money in through that. But the entire time, Mr. Marshall was always the representative. Mr. Marshall was always the controlling investor. Mr. Marshall was always the managing director of BVG, Spalena, and then took over as when they acquired ownership of NRD, took over as the director of NRD and was always dealing directly with the representatives of Rwanda. So it was certainly nothing to get around people in Rwanda, decision makers in Rwanda, the mining minister specifically in Rwanda, knowing that Mr. Marshall and his investors were continuing and reinvesting in a new set of concessions. I hope that answers the question, because what they do know and what they don't know in terms of the decision is frustrating even to this day on our side. We simply do not know why Rwanda wanted to leave it in that state, and so, but they did, and the parties went forward. Go to the next slide, please. So the way that this was handled is BVG had put some money into Bisesero, and that money was used to buy equipment. That money was used to pay miners and pay other operational costs. It was now switched so that what could be removed and reinvested as hard assets, it committed to transferring to NRD, again, through putting it into, transferring it to Spalena, and then putting through the ownership of, through the acquisition of the owner of the parent company of NRD, putting it into NRD directly, and then going in and working to build it out with miners and operate. BVG put in hard equipment and put in $100,000 loaned to NRD for use to operate its mining concessions the same way he understood that the operational costs, maintenance of equipment, use of equipment, employees, etc., all required investment to continue to develop, as profitability was a ways off. So the investment was not to get an asset that was throwing money out. The investment was to get an asset that was requiring additional money just to keep moving toward the day when profitability would be available. And so BVG made $100,000 of immediate cash available for that purpose and transferred assets. This cooperation agreement was heavily attacked we think, completely inappropriately. And we intend this will be now the subject of discussion with Mr. Ehlers as to why he denied that this was a real document. But the fact of the matter is, not only is the document real, but this happened. DVG put this money in. Stark was out. There's no dispute between the parties, despite all the shadow that's casted over the lack of records that exist from the the headquarters or the operating offices of NRD when all was said and done. To take back the years of records of payroll and other expenses, day-to-day, week-to-week expenses, we don't have them. And such shadow is cast over that as to how it couldn't possibly have been, but nobody has ever come forward from Rwanda and disputed. There were miners there. There were miners there working. They were being paid. There was security there the whole time. There was equipment that the miners were using, had to be maintained. The money was not coming from Stark. The money was not coming from profits earned by NRD. The money was coming, which started with $100,000 invested into NRD in cash from the beginning, and it kept coming, and it included things like payment of tax responsibilities, etc. The money grew in size, all of which we understand, and we're not going to cross the line in terms of the bifurcation. We are not to get into how much money was lost and how much damages exist as a result. But the idea that money was put in is attacked by saying the document's false, so therefore nothing was put in. But then nobody explains how years of operations, maintenance, security, etc. were paid for. If it wasn't DVG putting money through Spalena into NRD. This was the beginning. Next slide. In November 2010, NRD applied for the long-term licenses as its initial licenses were coming to a close. The long-term licenses at this time, and I'll repeat it in a moment, were 30-year licenses. That's what it was looking for, and I'll explain that in a moment. Rwanda now has a theory that, well, NRD actually, what you bought into, what they were actually only seeking was a 5-year license. And they point to language in this long document and long submission that NRD made. And admittedly, this is before the full ownership of NRD was acquired from Stark. But BVG was already investing in NRD because that was the transaction it was contemplating, working on, heading toward, and it needed to keep NRD moving, keep it operational. So it already made its investment direct, going to make the acquisition shortly. And in between, before the initial licenses expired, NRD submitted this application. And like the initial licenses discussed, it needed to have certain information about its investment, its feasibility study, a projection of how that investment was going to be used to build out the mining operations of the concessions in a way, because environmental analyses were also required, and alleviation was a focus of what was required to be submitted as well. How it was going to be built out, not only in a way to get the investor to profits, but in a way that would not harm Rwanda's long-term environmental and other interests. All this needed to be explained at the time of the application. And because the feasibility aspects, all of those aspects of the required submission are intertwined in this document. And I'm sorry, I don't see the 35. This is Claimant's Exhibit 35. I apologize for not noticing before that it's not on the face of this document. The C-35, very lengthy document. When the tribunal focuses on it, you'll see that the required elements of the application for long-term licenses, what it required, the feasibility study, analysis of the investment that was intended to be made over the life of the investment over the 30 years, what money was going to be coming in, who's going to back it up financially, what environmental studies and analyses were presented to show how this was going to be done safely. All of this is intertwined and repeated in terms of breaking out and intertwining, concession by concession. In other words, there's not
Mr.
one.
Cowell, could we look at the top of page 13 of this document?
Can you bring up C35 from the bundle?
Yeah.
It's not in the PowerPoint, so we have to toggle over to the bundle to do that.
Could I read it slowly? It is herewith applied to retain the concessions of Rutsiro, Gichiche, and Sabea as exploration licenses, albeit with a reduced aerial extent. Can you show us which part of this document applies for 30-year concessions?
Yes, and I started with the cover because I know that Rwanda pointed to that. The application for renewal of exploration licenses and application for the allocation of mining licenses. It's both. It's two things. They're applying for both. And the reason for that language, the reason for that focus, as we understand it, now obviously Mr. Marshall did not himself submit this document, but he is aware not only of this document, but he's aware of these submissions relating to others, is everyone did a 5-year projection and feasibility study. No one could in the mining industry, no one they worked with as consultants, no one they worked with as geologists, other experts, no one was prepared to do a 30-year analysis and study of feasibility long-term in that period of time. So it was referred to in terms of the exploration as that was the feasibility aspects of the submission that was required by the initial exploration licenses. And that was only for 5 years. I believe in the comparators that we're aware of, one was for 6 years. Everyone else that we're aware of is 5 years only. And according to our submissions, our understanding, all the experts, all the people that were working on this in the mining industry would only speak in terms of 5 or 6 years and nothing else. So you're right that language is there, but that language is not the only application. It's not only asking them to approve feasibility for only 5 years because that's all they were prepared to submit and provide information about, but they were asking for the allocation of mining licenses. And 30 years is not mentioned in the document by NRD because it would have been irrelevant. It would have been unusual to think in terms of having to name how long the license was at the time this was submitted. It's only an issue now because we're looking at this and arguing about this through the prism of Rwanda deciding to change the law. And they changed the law during the course of the process of the negotiations of the contract that was being drafted as a result of this application. It changed the law, and the 2014 law talks about applications for shorter periods and longer periods and what would be required of each, but not then. And if you go to the next slide, what in fact, that application for mining licenses was governed by what anybody who would submit it would be referring to as the law that was in existence since 2008. And this is marked the Claimant's Exhibit 20. Again, it's a longer document. But if you go forward, there's various articles about the mining application after the initial exploration period and a mining license for a large concession. And not only were all of NRD's concessions large, to claimant's knowledge, these are the largest, if not the 5 largest. They're within all of them within the top 10 group of largest mining concessions in the country. So they're clearly applying in each instance for large mining concessions. Shall be for a period of 30 years, period. That's it. So no one submitting an application for a mining license for a large concession in 2010 would think to say, and we want it for 30 years. They did want approval and sign off on a feasibility study of only 5 years, because that they felt was all that was, and Mr. Marshall will be addressing this. I'm sure he's addressed it somewhat in his papers already. That was all that anyone in the industry was willing to ever take on. So they did want to get Rwanda to agree to accept a feasibility study and a projection out for only 5 years, as opposed to 30. But the licenses it wanted were for 30 years. That was the only license to be given under the law. Next slide. And later that year, the discussions with Stark culminated, and Spalena was, because of Mr. Marshall's difficulties getting an explanation for how to address BVG going forward with Rwanda's ministry regarding the corporation's registration, they founded Spalena and acquired the ownership interest of NRD and inherited its investment, including its application for long-term license. That document is the claimant's exhibit 68. One moment, sorry.
Yes.
Mr. Cowell, there is reference, as we see, in Chapter 4 of the mining law of 2008, it's Law 37. Article 57 refers to a vast mining concession. And you have helpfully included that in your presentation. Can you explain to us what the vast mining concession is about, and whether there was an application that Mr. Marshall relies on in relation to a vast mining concession?
Well, a very good question, and I do not mean to be unprepared to answer it, but I don't think I've actually posed and gotten an answer directly the way you posed it. I can say from my understanding and work with the claimants in this case throughout, my expectation and understanding of the answer to a question like that from Mr. Marshall and his the other claimants' witnesses that were involved in the mining industry and their own specific mining concessions that they applied for licenses, refer to the large concessions as different from small mines where artisanal mining was the long-term projected only economic use. And I haven't asked them to distinguish and identify in writing where what they refer to as large concessions were all the ones designated as vast. I can't say, therefore, that there was a written document between the owners of mining concessions and the licenses and Rwanda that specified by name the so-called vast, as used in the vast concessions as used in the law of 2008. What I can say is that the claimants' witnesses who I've spoken to that are involved in the investment in mining concessions talk about a knowledge and understanding within the industry that there was a divide between large concessions and small concessions. And I have always taken and understood what they reference as the large concessions is the vast concessions as referenced in the law. And someone investing in one of those concessions was being asked to invest in developing, industrializing, making significant long-term inroads to fully exploit a large quantity of valuable minerals, but it would take a lot of investment over a long period of time to extract them. And someone had to come in with expertise and plan how to do it, not only how to do it profitably, but how to do it safely for Rwandans and the environment, et cetera. They needed the professionals, those with real experience in the industry that would be paid to come in and get it right. And that's why they asked for these experts. And that's why they understood, at least they were being asked for these expert analyses, feasibility studies, et cetera, to explain how someone comes in and develops out a large scale mine. And that on the other side of the divide are mines that no one was contemplating someone would find profitable enough to do something like that, and that it was far more opportunistic mining, artisanal mining. The industry uses artisanal mining as seemingly a term of art that everyone understands. But apparently, as I've come to understand it, it could capture under that umbrella individuals with a bucket, a pail, and a shovel, and it could include more professional, organized group of workers tapping a vein and running with it, but that it wasn't such a rich vein, it wasn't so deeply varied, that significant equipment and other measures for safety and significant entry to the vein and extraction, et cetera, was required. Individuals could do it with manual labor, working together, and some equipment and industrialization includes as not just the vast equipment, but power tools, air compressed jackhammers, that sort of thing, where it would require some capital, some business investment and oversight and management, and a number of employees, and that those different groups, and I'm sure those are just a couple of permutations in the whole range, all fit under the umbrella, as I've come to understand it, of what's referred to in the mining industry as artisanal mining. And as I have had it explained to me, the divide in the 2008 law between vast and the non-vast or the small mines was the concept that the non-vast mines would be long-term artisanal mining, and the idea was to opportunistically, again, safely and environmentally soundly, but opportunistically, someone to come in, exploit it, and leave, and there was much less concern about long-term damage and other things because that was never going to be put in the ground. The vast mines include all of these concessions for NRD. All of these concessions are, if not the largest in their category for the minerals that are identified in there, they're within the top couple for the categories of minerals that are primarily expected to be extracted from there. And frankly, that became a bit of the sticking point as time went on. Significant pressure was put on to break it up. That, okay, Stark got 5, and Stark got 5 of the biggest. Maybe they should be broken up. Maybe give up something, and you'll be allowed to proceed. And the reason we say that lingered behind that is because of the size, because of the long-term value of these concessions. So they were clearly all on the vast side by definition. That's our understanding, and that will be far better explained by witnesses such as, well, first of all, Mr. Marshall, but he has other witnesses in the mining industry that could talk about the distinctions between the mines and the size and what constituted the vast and how they differed long-term in terms of projections and what was expected of them. I hope that answers the question. Next slide. So from that period of time, now Mr. Marshall is NRD. He's in charge. He's the director on the ground. It's his equipment coming over, working with the miners who are operating it, putting their money in to NRD, and he takes over the negotiation from the submission that has already been on file, the application, he takes over those discussions about moving it forward as they anticipated. And again, his understanding of the process was not new to acquiring through investment the NRD interests. Mr. Marshall knew about the process, had the whole understanding of how it worked, who to work with, etc., for years, because he was involved in Bicicero and he did understand from his own experience exactly what he was doing. He gave up Bicicero in the sense that he was willing to allow it to be taken back without arguing about it. There's no question, but he was never really gone from the mining industry. He focused on investing in Stark's NRD, Stark's interest, and taking it over. So Mr. Marshall was involved in the mining industry throughout. He understood it. Taking over, he was working with people he already worked with, people he already knew. He's working with a process he already knew. So this was all very familiar to him. He understood it, and he had ongoing discussions for quite a long time. And those discussions moved beyond the application. What was submitted, was it correct? Did it have all the information? Was the necessary first step, because the initial NRD exploration licenses expired in 2010. Their application to go forward and get the long-term licenses needed to comply with what they were required to submit. That had to be reviewed. And it did progress beyond that in his discussions. And can you go on? And there's a witness statement, and you'll hear from the witness. Sorry, what's Dominic's last name? Apologize. Forgot Mr. Bodega's last name, and I apologize to Mr. Bodega in his absence. Dominic Bodega and Mr. Marshall, on behalf of NRD, undertook, as 2011 went on, to be discussing and cooperatively, just like from the beginning, there's this cooperation on, let us tell you what we're looking for, let us tell you what we're expecting in the contracts, let's look at others. This was nothing new to Mr. Marshall and Mr. Bodega. We saw from the early 2006 emails, it was the way things were done. Everybody on the mining industry side wanted the investors to come in and succeed. All the investors who came in wanted to succeed. They worked together to help build this out. It was a new, young industry in terms of privatization on both sides. The cooperative working together was not nefarious. The cooperative working together was not clandestine and hidden. I say that, I feel I have to point that out, because that's exactly how it's treated in Rwanda's paper. Mr. Bodega worked closely with Mr. Marshall or NRD's proposed contract, because that's what was expected of them. They wanted the contract to be acceptable to the ministry and ultimately the cabinet with the minister's support. They didn't want it to fail. So they point out, Rwanda now points out that somehow something nefarious must be going on, because Yahoo accounts for Mr. Bodega were used in these negotiations. That was just true at the time. Having a Rwanda.gov email account was relatively new, and how it rolled out for what employees at what time, we can't say. But they had conducted business with their own personal accounts, government business, for years. And the lingering use of both when they existed is true, not just from, and as the course of the hearings go on, we will point out for others, including Rwanda's witnesses, continued to use personal accounts with absolutely no question or concern that was somehow inappropriate. At the same time, they had government accounts, because it was such a long-standing necessity to use those individual accounts for so many years in the country. It continued. And Mr. Bodega at this time will explain why he signs this email as director. His official title as assistant is something that was also a mix, because Dr. Michael, the official director, was both on leave for studies abroad and on sick leave at different periods. And therefore, Mr. Bodega had to assume the responsibilities of director in his absence. So Mr. Bodega, officially the assistant director, one of perhaps, but for the Rwanda Geology and Mines Authority, was working with Mr. Marshall, and Mr. Marshall understood, and as I understand from Mr. Bodega, true of other applicants, he was working with them on contracts. We're at a stage in 2011 where the administrative agency that is responsible for working with the minister of the mining industry, that's ultimately to approve the licenses, he's working on behalf of the government, is working on a contract for the long-term licenses. That means the application was not rejected. It was not looked at as insufficient. It wasn't looked at as something that was a step that hadn't been met yet. You don't get to talk about a contract until you're talking about finalizing what was expected to be approval. Now, we argue in the expectations, and that's obviously an issue that the tribunal is going to decide. But what I'm suggesting here is the expectation that that's the goal, the expectation that having an approvable contract, one that will be first and foremost put forward and supported by the GMA, or excuse me, the office is referred to repeatedly in the documents as OGMR, Mr. Bodega's office, was only a step if the application was something that was accepted to be acted on. And so when I say that there was expectations of progressing toward the long-term license, it's supported, it's coming back to Mr. Marshall that this is progressing as normal, as always expected. The licenses are to be issued. The question is, what are the terms? What will be acceptable to the minister, et cetera? And those discussions were well underway in 2011. In 2012, things hit a bump and they go sideways. And the report back out as to, is the contract approved, lingers. And Mr. Marshall has spent a lot of time, others of claimants' witnesses have spent a lot of time in their witness statements, and I'm sure you'll hear a lot of testimony and questions presented to them about that during these hearings. There's a lot that went into things starting to go wrong. In hindsight, in retrospect, what you can see, what seems apparent on its face, is the string of things going wrong in terms of Mr. Marshall's expectation that the contract negotiations would be completed face-to-face negotiations, terms documented, finalized, never quite getting there, was a long endurance test, apparently one that he wasn't supposed to endure and come out the other side of. Giving up seems to be or having NRD, Mr. Marshall and his investors give up, seems to have become the intent somewhere in this period. But at the time, he did not know that. At the time, when we say his expectations were that the contract was about to be approved, it's because of the discussions that led to it and preceded it, and the purpose always was he should be successful. The Rwandan offices that he was dealing with, the minister ultimately wanted investors to be successful. Mr. Marshall had no reason to think otherwise. So the investments by BVG continue. March 2012, BVG puts additional asset, invest more money in acquiring over time. It wasn't all at one fell swoop. I'm just suggesting this is the date of the documentation as to the transfer of ownership, but equipment, heavy, small, etc., acquired by BVG when it starting with its original investment in De Cicero, going on and considering building out, developing, meeting the feasibility analysis and expectations that were submitted for the NRD concessions, all required investment in physical equipment. Purchases were being made around the world. Significant amounts of equipment were purchased by BVG's investors. These were all transferred to Spalena so that BVG, the investors, treated the BVG interest as now part and parcel of ownership of Spalena, which owns the parent company, all of which is funneling the money from the outside investors to NRD in the country to operate, run the mines, and all the equipment that is being acquired and purchased with that long-term development of the mining concessions is transferred for that very purpose, for NRD's benefit and long-term use. Because again, at this time, Mr. Marshall and his investors' expectation was things are going as they should be going, keeping in mind that the investment that they had made to date, the investment that they're making in acquiring this large set inventory of equipment, this is not sufficient to meet the long-term goals and build out of 5 mining concessions owned by NRD. The successful progress forward, including the award of the licenses, is necessary to fundraise much more significant investment outside. Primarily, again, Mr. Marshall was identified as the person with the contacts in the U.S. for investment. The idea was investors would come in on those contracts with a 30-year period of investment to realize the profits from their investment. So BVG wanted their ownership of Spalena to be clear, and this is how this transaction is documented so that BVG is clearly a major shareholder in Spalena, and anybody putting money into BVG would be acquiring an interest in the company that owned the parent of NRD. So this internal transaction and lining it up for future investment, again, consistent with the idea that it all matters. The investment is going to be something there that, one of the next steps after getting those concessions, long-term licenses for the concessions, excuse me, is to raise more money and more investors. They're lining it up so that that investment vehicle makes sense. Bayview Group takes a major shareholding in Spalena, and it's all uniform. Clean set of investment books for someone to come in from the outside and add more to. So this list we point to as some of the in-kind, the asset hard investment that BVG made in NRD through transfer to Spalena. But as 2012 goes on, those discussions that Mr. Marshall was expecting face-to-face with the minister or otherwise, who the minister sought to work with, finalizing the contract, just weren't scheduled, didn't happen, and operational questions, operational blocks for NRD started to pop up. The Rwanda mining operations were, the minister's office shut them down in March. C47 documents Mr. Marshall on behalf of NRD's complaint about the fact that there, this order of shutdown comes and he doesn't understand it. There's no explanation. Why is this happening? Discussions about just getting back on track start taking over, and as we'll see, and as you've already seen in the witness statements, they become what all the energy becomes burned on. What all the activity and energy is about is just getting back to the minister treating them as operational and moving forward, and that continues throughout 2012. I point out that while this was going on, while there seems to have been a gradual, there certainly was a pause in the discussions of the contract to be signed for the 30-year licenses, there seems to be agitation about how the minister feels about Mr. Marshall or his investors, NRD as a whole. Perhaps the concessions is the focus, but there seems to be some agitation inside about how to deal with them. Nevertheless, there was no question at that time, contemporaneous, that Rwanda understood there was significant investment by NRD significant investment in NRD for these 5 concessions, standout investment compared to the other mining concessions at the time. So in C14, you'll see a promotional manual put together by the respondent. Next slide. And you'll see NRD identified as one of the investors. Spalena is the owner. They acknowledge that. They go on to quantify a $39 million investment. So in promoting investment, promoting the idea, soliciting other interests in investment in the mining industry, they're identifying the investors in NRD as already putting in $39.5 million for their concessions. And now we see and hear from Rwanda a very different perspective, that somehow there's all sorts of questions and Mr. Marshall can't document and back up his investment. There was no question at the time. They were so confident of it, they were telling other investors to rely on their information. In August of 2012, Mr. Benzingi, one of the early investors with the predecessor to Stark in NRD, starts agitating that somehow he has a greater interest, but he far overstates his interest, and the dispute of that covers a number of topics that you're going to be presented with in the course of the witness testimony, because advising the co-investors at the time as to how to deal with Mr. Benzingi's interest and get all that right and move forward so that their interests as a group could be sold to Stark as sole owner. Rwanda's witness advised on that, his firm advised on that and helped approve. Now it's all called into question, not only by Rwanda, but by the same individual. But Mr. Benzingi's calling it into question was promptly resolved by the office in Rwanda responsible for maintaining the records of corporate ownership, registering who the correct owners were. The agency with the final say resolved this concern. Very disruptive concern for a week, but it was resolved by August 8th. So between August 2nd and August 8th, Mr. Benzingi was able to agitate and cause a great deal of stress and problems for Mr. Marshall. Now, keeping in mind, none of Mr. Benzingi's complaints about how he was handled and what was done with his interests involve Mr. Marshall. That's not his investment. He bought it from someone who bought what they understood to be all the shares in the company, and the former shareholders, Mr. Benzingi included, in the Zarnaks, being paid by Stark. All of that was handled before Mr. Marshall and, through Spalena, made their acquisition from Stark. But a great deal of agitation and disruption to Mr. Marshall's on-the-ground directorship and management of NRD through his ownership, through his investors group's ownership, was quite a problem that Mr. Benzingi forced them to deal with. And RDB did deal with it, got it straight, and Mr. Benzingi was put back out, and the RDB, in analyzing the situation, agreed as to who owned controlling shares of the company, who was the majority owner, who had the right to appoint the director. Mr. Marshall was restored to that recognized spot, and at that time, he thought it was over. It was very disruptive that he was concerned that anyone within the government would let someone like Mr. Benzingi do this all these years later, and based on his allegations. He was complaining about it at the time, but it was resolved by those people charged with the responsibility to look into it. At least that's what Mr. Marshall believed. In September of 2012, as the period for the discussion about the contract, finalization of his terms, and signing the contracts for the long-term licenses continued to drag out, to Mr. Marshall's frustration at the time. Nevertheless, the respondent identified that they were remaining licensee at the concessions while that application was being considered. And I point this out, not because, again, it's the only communication about this, as Mr. Marshall's statements have made clear. There were numerous conversations, in person and otherwise, about, where are we on getting to these, meetings and discussions and finalization. But the reason for pointing out C-45 is the spin that's put on it in an extremely legalistic analysis of what can we call something. Decides the Rwanda's position now is they want to decide as if they're somehow gifted. They're permitted to remain, but with no rights to be there after expiration of the exploration licenses, past the application period for the long-term licenses. NRD, they say, wasn't really a licensee anymore. That's not what was reported to them and to generally to the concession holders. In August of, I'm sorry, what was the date? September of 2012, a written acknowledgement that as these discussions were continuing with the concession holders, the existing concession holders, I actually just quoted from the part that's not highlighted, in between the two highlighting, as has been communicated to all the existing concession holders. That's how they're talking about NRD, Mr. Marshall and his investment group at the time, your existing concession holders. Because new contracts that will be negotiated, they're being told, we will be talking to you about the contracts. Again, I pause here. This is September 2012. Months after the application was filed, months in, it was the prior year that a draft contract was, it was in 2011, we saw a December communication, but in 2011, there was communications about beyond the application, let's start drafting a contract. What are you looking for? What's acceptable? In September of 2012, Mr. Marshall is again being told, his investor group is being told, new contracts will be negotiated. You're only in the phase of negotiating a new contract with the original exploration license holders. If their application was timely submitted and considered appropriately fully submitted at the end of the exploration licenses for the long-term licenses. That's all that exists under the law at the time, and the law that Mr. Marshall thought was applying to him, and the other concession holders thought they were applying to him. So when being told that we are negotiating, we will negotiate contracts with you, there is no question on the table that we're considering your application and aren't sure that you timely submitted one. We're not sure you qualify. None of that happens at the time. That's not contemporaneously what they say. It's only later an explanation of, well, in fact, you didn't, and in fact, it wasn't good enough. You must do something different. But at the time when Mr. Marshall's saying that's not our expectation, that's not our understanding, that's not what we were being told, and he's being accused of lying when he says it, he points to respondents' own language, respondents' own letters, and says, no, what I'm saying I expected is what you're telling me to expect. You will negotiate the contract with us. Just taking longer. But the disruptions to the actual operations continue. And in September, example of a letter complaining about, summarizing some of those disruptions that are going on with government officials' apparent backing, support, is C-49. Arrests and disruptions of the miners and activities at the concessions make it appear that somehow there's a question whether the ownership, the management can maintain the security. But Mr. Marshall complains they're being singled out for such bad treatment. They're being put upon, and the miners are calling to call into question what is happening when no question should exist. And then in September, again, just to stop operations. October, operations were allowed to continue after the stop in the Western regions for everyone. October, it becomes, well, operations may continue, but not NRD. And C-50, December 2012 letter, December 14, 2012 letter from Mr. Marshall points that out, complains about this. Again, why are they being singled out? Why are the other concession holders being treated as if this problem, this concern that's supposed to shut everybody down, their operations can continue, they can continue building out, they could continue trying to make the revenue flow for their miners, et cetera, during this time period. We can't. Why are we being singled out? This becomes the constant theme of the concerns that are going back and forth. Mr. Marshall is saying, but you're treating NRD differently. And it wasn't until February 2013 that finally NRD can resume the mining activities. As we proceed with negotiations on your request for new contracts. So the disruptions, the problems, the head-scratching lack of answers to what's happening, the ominous signals that he's not liked or his company's not liked, his other investors aren't liked, the fact that he has these 5 big concessions isn't like something is off somewhere, it seems, to cause these constant problems. But again, repeated, despite the problems, you're seeing one thing, you're experiencing one thing, but hey, we're going to negotiate that contract. Again, we recite back, there's no question what that means to anybody who's familiar with the 2008 law. They've been operating under it. Contract for your size concessions, 30 years. That's what we're going to negotiate with you. Sorry.
No, just slides off.
We skipped one. I'm sorry. Apologize for that.
Just slides off.
Which one?
Nope, you're good. Keep going, sorry.
Apologize for that break. In April, Mr. Marshall, on behalf of the NRD, is invited to continue to negotiate for those licenses. And he thanks them for that opportunity, again, confirming what he said his expectations were. This is the communication that's going on one level. This is the discussion. He's expecting a negotiation of a contract means terms will be set down and the license will issue. And he's being told to expect it repeatedly, being invited to participate, and it doesn't happen anyway. Not, as you've heard from Mr. Marshall in his witness statements, and you'll hear more if there's any questions asked him about it, not because of lack of effort by Mr. Marshall, Ms. Susanna. I apologize for not being very good at saying her last name, especially with a dry mouth. You've heard them, you've seen them, excuse me, report. Efforts were continuous and they were tireless to make it happen, but they're not happening. And by October 2013, still, it's out on the table. It's going to happen. It's going to be discussed. Let's sit down and talk about the mining licenses. But look, it's April to October. It's still being left as let's schedule a time. Let's have the conversations. The ability to get the contracts, supposedly just some negotiations and discussions away, but that dangled negotiation didn't happen. Meanwhile, the entire time, investment continues. There's no abandonment of the concessions. There's no stop work as to the extent it could be done. There's no stop of security. There's no lack of maintenance. The concessions are being invested in just to be maintained. It is not the case that the investment, like a light switch, goes on and off as you generate minerals from a mine. To have roads, to bring in the equipment, to bring out the minerals, to do things long term that meet the feasibility study. Work has to be done, preparations have to be made, money has to be put in the ground. And what is there and what is being done and what people are making the smaller revenues from artisanal mining that's occurring has to be, again, maintained. Employees have to be there. They have to be housed. Money's going in, not the kind of money that will flow to build out the full-scale mines after the concessions, but that doesn't mean nothing. And that's how it's being treated here, as if somehow there's some mystery that Mr. Marshall must prove because records, accounts, payroll, the rental payments, the purchases for the equipment coming in and building roads, because we can't put them on the table, can't be. The roads were there, the people were there, the housing that was there, the plant that was the best industrialization example in the country at the time. The plant had to be maintained, whether it was processing tons of minerals a day or not. It had to be maintained. It couldn't just sit. So while this is not happening in terms of the 30-year license and more money is not pouring in to ratchet up everything, money is still going in. And then things change. Now suddenly it's the prism of, well, start over. And that's because the 2014 law passed. And in hindsight, the long awaited, long dangled, but somehow couldn't get held conversations and discussions on the terms of those contracts that are going to issue to you seems to be a stall tactic, seems to have been a wait and see. This is what we want before we actually have another meaningful conversation with you, because there was no explanation ever given why a meeting couldn't be held about the contract. It was well underway in 2011. We're now in 2014, and suddenly the world is supposed to change for NRD, because the enactment of law 2000, the 2014 law, and the position takes a 180. About face, we're negotiating new mining agreements, but under the new regulations. And as Mr. Marshall has testified, as other witnesses have testified, there's an aspect of the claim that is, well, again, NRD is singled out on this. Again, our NRD is being treated differently than others on this point that were in the same situation. Original exploration licenses, applications for long-term licenses, in other examples, not even as good a state of current investment and development as NRD. They're not reapplying and starting anew. That's one aspect of it. But the purpose of the selection of these items of communication has been, to be very blunt about it, is to say, you don't even have to look outside of NRD itself to see a complete and utter change in position, that it does not fit. This is not preceded by any expectation, any reasonable expectation an investor prior to this date would have as to what Rwanda's intention was with regard to long-term licenses for the 5 concessions, without even asking, well, what are you doing with the other concession holders? July 14, Mr. Benzingi comes back and says that he obtained an arbitration award, an arbitration that NRD didn't attend, in which he disputes a transaction that Mr. Marshall and his investors weren't involved in. And he says that the result of that arbitration and what he says the arbitrator said his real shareholding should be, that he was deprived of, should allow him to take over NRD as it currently existed. Now, there's an awful lot to be said, and there has been some discussion by Mr. Marshall and at least, and Susanna as well, I believe, about how challenging this presentation was by Mr. Benzingi in terms of going forward with an arbitration where they had identified a conflict of interest with the arbitrator and Mr. Benzingi, and were expecting that conflict to be addressed. And meanwhile, the next thing they hear is an award issued. But more importantly, the logic of an idea that someone who went from less than 1% interest holding to a full 15% interest holding because of a shareholding agreement with 2 owners removed, those owners who treated him as a less than 1% interest holder in going forward with a transaction and were paid and left with the money, Mr. Benzingi said his award established they didn't treat him correctly. But to come 2 interest holders later and say that I want your company, as opposed to going after the Zarnaks, who got the money and, according to your math, got your share very wrong, they're fine. I'll leave them alone. I want the company. For 15% interest holding, he wants the whole company. And the respondent gave it to him. showed up with a bailiff, took possession, waving around an arbitration provision, calling him a 15% holder, or 15% interest holding not recognized. And Mr. Marshall was put out. Zuzana was put out. Now suddenly they're told, you're not really the owners, managers, directors. We'll deal with Mr. Benzingi. And that's first by the bailiff, and then the minister says, well, this is a big concern to us, which is at a whole nother level, extremely frustrating to the investors in NRD. Why is the Minister of Mines, the mining industry, getting involved in what a shareholder agreement on a transaction long ago occurred, may have been honored or not honored, and what it may mean in terms of what Mr. Benzingi is owed? Why is the Minister of Mines getting involved in that? If that interest holder wants more money for a 15% share and was treated as less than 1% owner, NRD still exists. NRD has been handling the concessions. NRD's been investing. The entity and its original licenses, application for new licenses, contract proposal for the terms of those new licenses, all on the table. And to say, well, we can't deal with you anymore because Mr. Benzingi says he owns 15%, so nobody's getting anything, nothing's happening. And you know what? You can't even sell your minerals. There are miners. There's money being put in to both secure, protect the concessions and the miners. There's work being done. People are housed, things weekly, monthly, etc. Money is going in to make this happen, all relying on the revenues that can be, expecting some revenues to be generated while this continues from that mining. And now suddenly it all can't move. Can't do anything with it. You can mine, you can't generate a sale. We're just going to prevent you from tagging. And the background of the so-called tagging requirements all put in place to deal with the U.S. import regulations and statute that prohibited importing minerals or products made from minerals from so-called conflict countries, requiring assurances, requiring averments about the lack of any such minerals coming into the country from those importing. All of this is a huge concern. How are we going to deal with it when, for the long history, as you've heard from some of the witnesses, claimants' witnesses, has been minerals were coming from Congo, a conflict country. Conflict minerals had been in Rwanda. How are we going to assure that they're not what is being exported from Rwanda? There's a tagging process. There's going to be a independent body in place as to assurances, and the tags are everything, because if it's not tagged, well, then it's not assured that it's not a conflict mineral, and import it into the U.S. So you can't really sell it in the open market if the U.S. imports are excluded. This is the lifeblood of the ongoing industry, in artisanal as it may be at the time, the smaller scale as it may be at the time. The ongoing mining and selling of minerals in Rwanda from its mines requires the application of these tags. Rwanda is in control of it, working with ITSE. And the Minister of Mines says no more to NRD. If Mr. Benzingi is a 1% interest holder or 15% interest holder, those mines, those minerals came from where they came from. Those miners who put in the labor put it in and need to be compensated. NRD needs its share of the revenues to keep paying for the things that allow that to happen and not have it fall apart. There's no question what stopping the tagging means. And the stark disconnect between tagging minerals as validly mined on site in Rwanda and Mr. Benzingi saying, I want what Mr. Marshall has because other people years ago did something that I don't like and I think is wrong, is astounding. And nevertheless, in justifying it, Mr. Vodamina, the minister at the time who made this decision, it's a personal decision. He specifically, looking at NRD, chose not to let them participate in a supposedly neutral, as to be applied to everyone equally, law. And he felt perfectly comfortable, so comfortable he's come to you and said, yep, I did that. That's what I did. Personal decision to specifically say no to NRD. Because I want to put pressure on them to regularize their operations. Regularizing operations are being managed by Mr. Marshall and his investment group. So Mr. Amina, looking at Mr. Marshall and the investors, said, I want to send them a message about what I want to see happen, so I'm going to stop giving them the benefit of the law. That, we say, we start this proceeding with a concession of a violation of the treaty. Next slide. And the pressure then continues from Mr. Amina's office. Got to reapply, got to start over. Somehow now, after the law of 2014 was passed, despite what was treated and the reasons that come forward, and everybody's got an explanation for, okay, others don't have to do it for all these reasons. We've got to start over, as if the application was not timely and fully filed. They're treating the 2010 application for 30-year licenses as non-existent. Got to start over. But as we've seen consistently prior to the law of 2014 passing, when apparently they knew what they were looking for in the law and they were working to have it accomplished, but it didn't exist, they were referring to the contract negotiation stage. We're past the application stage. And then it all becomes focused on, well, your new application it's got to be submitted. That was running a push for that again in August 2014. Next slide. In October of 2014, sorry to inform you, bring up the slide. C-119, sorry to inform you, the ministry has decided not to grant you mining licenses based on your new application. So, according to the Rwanda's current position, of course, when something like that is said, that's definitely final, right? If they tell you no, no means no, and you're done. It's not how it works. That's not how it worked in Rwanda. They say Mr. Marshall is completely unreasonable to suggest he ever had an expectation that yes could result after a no. And yet, after a no, sorry, you're done. Next communication, that at least the next communication that I'm going to highlight, I'm not suggesting, I pointed out, I do not represent, there is no communications in between. As a matter of fact, it's going to refer to one. C-87 shows that, I'm sorry, the date's blocked. Oh, I'm sorry, it's at the top. November 12, 2014. Because you pushed back to the no, we say submit new things. We're back in considering a new application mode. So no becomes yes. Well, no, excuse me. Completely misstated that. I did not intend to say it that way. No becomes maybe. Let's keep talking. Keep trying. That's what he's in as of November. That's what the investors are in as of November. Try again, but start over. They, of course, say, we did successfully start the application process. We're in the contract negotiation phase, but they're trying to comply. They're trying to appease Minister Amina. next slide. Quickly, just the next slide. Oh, I'm sorry. This goes on to a little bit of different topic. So we have it's been pointed out to me that we have 5 minutes to break. Before I jumble back and forth, I asked the tribunal, would you like us to break now? I will try to summarize this and quickly finish.
Yes, I think we'll break now. We'll break now, but we will come back in 20 minutes.
Thank you, Your Honor.
Break now, come back in 20 minutes.
Okay, we're going to go ahead and open up the breakout rooms now for everybody. All right, breakout rooms are closed. Mr. President, I'm going to go ahead and go off camera.
Your Honor, may we start again? I'll wait for your word.
I believe you're muted, Mr. President.
I just got kicked out. Sorry. I'm sorry. I was momentarily out. So I apologize.
So I believe the president's still muted. No? Was he going to say something?
Waiting for permission to start. Yes. The next slide.
No, I do believe that the president wished to address the parties on one issue.
Oh, I'm sorry. I'm sorry.
Mr. President, you're still on mute. James, is there something we can do?
I'm going to send an ask to unmute, but I think they have a hardwired mute button there.
He's speaking and
Yeah, he's going to need the IT because they have external microphones there. Let's see.
there we go. Mr.
Right.
President.
Can everybody hear me now?
Yes, we
Yes,
can.
sir.
Yeah, good. I was apologizing for the length of the break, which was caused by the fact that the tribunal has been thrown into confusion by the hearing agenda, which is defective, in that it suggests that in London, we are now going to sit until 5 p.m. That is for 2 3/4 hours, when it should be 4 p.m. So we are going to sit for, as I understand it, for 1 3/4 hours now. At the end of the day, I want to discuss tomorrow's timing because the current timetable is not satisfactory. The tribunal needs a break of half an hour at the end of the first session of 1 3/4 or 2 hours so that we can eat a sandwich. When people are present from Kigali, they'll also probably want to have a bite to eat at that stage of the proceedings rather than waiting till it's almost time for dinner before we have our lunchtime sandwich. Anyway, we'll sort that out at the end of today. Meanwhile, let's go ahead until 4 o'clock our time.
Yes, sir, and my apologies for the error in the hearing schedule. Can you bring up the next slide?
Oh, one other
so-
point. One other point, please. The respondents vanished from the screen. The tribunal will be grateful if the parties always have somebody on screen, as it were, throughout the hearing.
Thank you, sir. May I begin?
Yes.
So in our timeline, and as I mentioned before, as a reminder, I am not suggesting this is the next event where Mr. Marshall, Ms. Moskova, I apologize for mispronouncing your name again, provided services to Rwandan entities and agencies, but I highlight a couple here just to, for example purposes, and I'll go through them really quickly. The substance is not something I'm going to dwell on, but in December 2014, in their other capacity, Mr. Marshall and Susanna were working with, bring it up, Ngali, which is a entity owned by the Rwandan government, at least in part. You know, they're working with them on a transactional matter, in a consulting, advising, and you know, role. So you see that seat 133. December 2014, another request about the reapplication, you know, somewhat critical, that they're asking again for documentation, that they want them to, everything's at this time is from the perspective of you must reapply, and they're citing the new application guidelines requirements, new being the 2014 law. And as you know, the parties' positions differ on this. They have a split of views, and this was consistent at the time. NRD's Mr. Marshall believed that the application was timely and correct and accepted under the 2008 law, and this was just not a point that the minister was giving on, and Mr. Marshall did the best he could to maintain his position and yet try to comply by resubmitting a renewed application. Go forward. And work continues in their other capacity. In this case, on behalf of the Rwandan government, in Ngali, the entity that's owned by the Rwandan government, at least in part, in a United States transaction, purchase of helicopters. Again, I apologize for going quickly here, but I'm not getting into the substance of the work being done here as important to this presentation. I will explain shortly the reason. I'm just laying out the context. In February 2015, Minister Baruta confirms that, on behalf of the respondent, that the renewed applications under review, again, referring to it as the long-term license application. And still work is going on. The other capacity that Mr. Marshall and Ms. Moskvorikova were in the country from the earliest of days, working with Rwanda in their advisory and consulting capacity, handling another, helping to facilitate. So this is the role of sort of a representative for Rwanda in making a relationship connection so that a transaction can be discussed between the representatives of Rwanda and Slovak Republic. Again, I stress this just as the context of this is a very trusted capacity. Rwanda is relying on Mr. Marshall as a face, as a voice for it in dealing very serious, presumably very valuable transactions and other matters for the country while this is happening. In March, NRD meets with the RDB to discuss ongoing issues and concerns relating to the operations of NRD, the ongoing concerns about how they're being treated and dealt with. They're not in a satisfactory position yet as to how they're being treated on this application, on this side, with regard to the mining investment, at the same time that these other transactions and other relationships with Mr. Marshall and Ms. Moskvorikova are continuing. Go forward. And then we get to May. After a few months of considering it, Minister Amina informs NRD, Mr. Marshall, on behalf of NRD, that the renewed application is denied. Similar, I regret to inform you that you will not get them. Similar, no, as in 2014. But goes on and says this, in order to finalize this, we're saying no, recognizing that, but they're there, they're operating, they're maintaining, they are running to the extent they can, the mining concessions. No one else is. You're going to have to hand them over because the government's saying no, the government's going to go forward and take over. And all 5 concessions are expected to be handed over because those perimeters, those areas, security for those areas being provided by the investors' money, the NRD's owners' money, the maintenance, the extent anybody's acting responsibly to maintain them and continue them, all through this time, just been the investors in NRD. So that's going to be turned over now because of the no. That doesn't happen. And just like in 2014, where we was told no, Mr. Marshall has provided a witness statement saying, I didn't expect we were done. I expected the process to continue. We continued to make efforts to negotiate and find what the issue was that was holding up the willingness to issue the 30-year long-term licenses, negotiate an agreement on how to resolve it and go forward. And he believed sticking with that process was the only way to get what they invested in and have a potentially favorable outcome, as opposed to being done, calling it quits and suing. And Rwanda's position is it's completely unreasonable. You never would have expected it. But that's exactly what happened in 2014. Months go by, the no wasn't really no, the no was maybe. Further consideration, further discussions held out as possible for long-term licenses, as they said, despite the no. And it's not just no, it's no and we're taking them over. Well, when are you taking them over? Then we're done. They don't take them over. They do not take any step to actually implement the no. And yet Rwanda's position is NRD's investors must have known it was over. They had to leave. There was no possible reasonable expectation of yes from here. Well, if they left, they would have been abandoning the sites. The government wasn't taking them over, not from them, and not really ending their control and possession of the concessions, not for quite a long time. And it's not just Mr. Marshall who says in this interim period, I did not believe we were done. I did not think it was over and declared that that Rwanda was not going to issue the concessions, not leave us with the concessions, and instead take them back. And we see in the record, Mr. Marshall's presented, the claimants have presented other interactions with the government where confusion is expressed as, well, what's the government, who actually owns it now? The government is not saying internally or externally to others any clear answer that suggests the claimants aren't the owners through NRD of those concessions and in charge of them. In this particular June 16, 2015 communication, there's reference by a potential outside investor who's in the country to look at potential investments, being shown the NRD concessions and having it referenced to him. Now, this is not Mr. Marshall doing this and inviting them in. This is the government. Having them referred to Mr. Marshall as the owner, and he's reaching out for some information about their concessions and their operations. That's based on information they're getting from the government and whoever they're working with to talk about a potential investment. That is not Mr. Marshall causing the confusion. He's just receiving this and recognizing they're still being referred to as the owners of the concession. It's June 2015. There's an ITSE transaction report, and as we mentioned early, you've heard a lot and you've seen a lot of detailed information about the tagging and of the minerals, the import, and who's running it is ITSE. There's a there's an occurrence report that ITSE prepares, and this is reporting to the government, and this is an agency that's working with the government to implement its laws, its process of tagging and monitoring the mines for the government. And there was a death at one of the concessions in September 2015. The government's arm, the body it worked with to set up and to help it implement its rules and its laws regarding mines, is reporting on its incident report in September 2015. This is an incident at NRD's concession. Now, the government, the respondent, excuse me, is saying here, Mr. Marshall's not telling the truth when he says that after May, he considered himself still at the concessions with potential ongoing interest in them and ownership, and that everything was going to turn out with, right for what they understood all along was eventually a negotiation of a mutually acceptable term for 30-year licenses. That's completely unreasonable. He's making that up. Couldn't possibly. Internally, so to speak, within the government dealing with ITSE, it's not reporting to ITSE. Those are our concessions now. So this is an incident where the government's in charge of the area where this death occurred. That doesn't happen until, if you see, because this is obviously a system that is interactive and ongoing, because if you see in the green at the top, Rwanda, July to December 2015 status July to December 2015, and this report was printed at the end of 2016. So information is being added over time. The initial start date is shown as a September date in 2015. The end date, the last entry, is a date in 2016. That end date entry in 2016 is that the sites to be publicly tendered. The GMD was contacted about the question of NRD, and the site is to be publicly tendered. That's reported to ITSE as to who's in charge, who it should be dealing with to try to remediate, address incidents like a death. The government finally tells it in 2016, well, that's us. You're not dealing with NRD anymore, you're dealing with us. And that is, as the claimants, have explained, it's 2016 when they really knew they were done. They really knew they were out. Go to the next slide, please. In September 2015, they were told to take all the belongings and get out of the offices. So it wasn't even until September 2015 that the government took any action to prevent NRD's investors, the claimants, from operating the main offices. They had them take their materials out, close up their office to them in September 2015. This is a C-163 is the text messages in which they were informed that that was happening, sort of at the moment. No advance notice, just this is happening now. They're going to close up your offices and you've got to be out. You're not going back in. In January 16, Mr. Marshall, in response to discussions that he was having, and I'm going to cover that backwards in a moment, but despite the discussions that were happening up until then, where he was encouraged that things may not turn out as badly as the May letter suggested, stay with the process, don't do anything precipitous. Get back to that in a moment. In January 16, he was told it changed. And now that's no longer a possibility. Rod, it's not safe for you to come back to the country. It's not safe for you here. It's over. That was January of 2016. Between 2014, 2015, up to, through January 2016, and in fact longer, the claimants were spending the money on security. The claimants were spending money on maintenance for the equipment and the plant that was on the ground to keep it ready to be pushed forward and operated by, for mining. They were paying for all that. The government wasn't. They continued to pay for it even after January 2016, but they were trying to cooperate, and certainly with Zuzana remaining in the country, they weren't going to do anything that made anybody act in a way that Mr. Marshall was warned he would be treated if he came back to the country. So from January 2016 on, they tried to appease and just turn over quietly control, and they continued to pay out of their pocket for the certain expenses. But he knew then, and for the first time, the concessions were not possibly going to be the claimants. And the reason I highlighted, but didn't spend any time on the substance of the representational capacity in which the Rwanda was relying on, utilizing, working cooperative with, and trusting the principles of the claimants throughout 2014, 2016, 2015, is when Mr. Marshall in his testimony, his witness statement, says that he was being encouraged to stay with the process, don't do anything precipitous. He firmly believed, had every reason to believe, that the people who wanted him there, that wanted to see him succeed in his investment, remain a successful investor in Rwanda with the concessions, and continue to be there and work in the capacity as representative of Rwanda, he had every reason to believe they were just as powerful, just as influential, that ultimately their view of what should happen may prevail, and not Minister Amina's. And the suggestion by Rwanda that only, once Mr. Amina spoke, the only assumption the claimants could draw is that he spoke and it's done, simply does not align with the reality that it's a very fluid situation, and others who have as much ability to potentially influence and dictate the outcome of this were on the other side, and did not want Rod and the claimants to leave, did not want them to do anything themselves to end the investment in the concession. And it was entirely reasonable to believe that they may have the ultimate say, knowing how closely they worked internally in the Rwandan government. The claimants knew the outcome was not determined until it was determined. And that message as to how it was determined was delivered in January 2016. Yes. It wasn't until March 2016 that respondent actually tendered the concessions and nationalized them, took obtained new money, profited from taking back the concessions that were originally awarded and to NRD's investors and re-awarding them. So the violation of expropriation really occurs ultimately in March 2016. There were many steps along the way that impaired the value, but the value was nationalized and taken back and capitalized on in March of 2016. Next slide. In January 2017, former Minister Evode Amina was arrested. Allegations against him included he was charged with favoritism in how he was awarding licenses. Prosecution alleged that Mr. Amina and his co-conspirators hastily registered a company which was fraudulently awarded a license to conduct mining in one of the one of the concessions. And that these events happened in 2013, 2014. Again, raised for the context in terms of whether Mr. Amina's position within the government, what he was doing and how people viewed him and what they wanted to see as an outcome, was clearly going to dictate. Mr. Marshall points to this and says the reasons why some people felt he was very vulnerable and would not have the final say and ultimately be around were reasonable to believe could very well have turned out to be true. And
Is it correct?
before-
Is it correct? Is it correct that he was acquitted of these charges?
That's the document that you ordered be given to us in full translation will tell us the full content of what was said in one judgment. We're not sure if it's all. We do know that in the document that they point to, there was a private party that was looking for compensation. We know that from the two paragraphs that were translated. I don't have any ability to say on the face of those two paragraphs in these articles how those two align, why a private party would be seeking compensation in a court proceeding and that be the court proceeding in which criminal liability is determined. I don't know. That's the primary reason we ask for the full translation is before we fully comment on the import of those two paragraphs, we'd like to know the entire context in which they were rendered. We do know that the co-conspirators were found guilty, so which wasn't reported by Mr. Amina, and so the idea that there was nothing to this is greatly exaggerated. Next. The sum total, in terms of summing up our presentation, I apologize for going so quickly at the end and slowly up until now, trying to hold to our time. There's 4 articles of the investment treaty that we say have been breached, have been violated. They are obviously, as in many of these cases is true, overlapping in terms of the conduct and actions that relate to one, relate to the others. In terms of national treatment, clearly the American investors were not given, and we've established and we've put forward some of those early exploration license holders who in no better position in submitting applications for long-term licenses to get them. In terms of the very issues that are held out as the reasons for rejecting claimants in the end, the amount of industrialization. Well, claimants had more. The status of the investment, just like the claimants, the investment, the real investment in developing was held out by TINCO as after the licenses are issued, that's when our outside investors will come in and the real money will be put in. Everybody understands why. Everybody gets the nature of big business and what they're looking for in terms of a secure investment. It was accepted as reasonable for TINCO, wasn't accepted as reasonable or put forward as a ground of, no, we're not willing to accept it from you, claimants. Well, the issue that for the treaty is TINCO's joint ventured at the time of the award with a state-owned mining company who had 90% of that company. So the award, the benefit of the award, the benefit of their interpretation of how these requirements should apply to TINCO was for the benefit of a Rwandan investment, the state itself, its commercial, one of its commercial arms, primarily. And that only changed very recently in terms of giving TINCO the majority control, and that was another issue in terms of the documents that you talked about this morning. So for the entire period that was applicable to these applications, this different treatment was for Rwandan benefit, primarily. Most favored nation treatment, a clause that just inexplicably is not really dealt with by respondents or the United States, but clearly there, and any investor would look at this, that If they're an American investor, they can't be treated worse than anybody else. Nobody else is going to get favored deals or favored treatment. Again, for the reason we just stated, that's not true. Rwandan and in dealing with a South African joint venturer was clearly given better interpretation, a different application to that application of the 2008 law, not 2014, different view of what meets the standards, even though the standards overlap to a large degree. And it can't be said that the same rules were applied to both sets of investors. Minimum standard of treatment, at the end of the day, they can't be grossly unfair. And what we put up regarding some of the conduct in 2012 and the details, you have far more events and conduct. The number of events that impaired the ability of the U.S. investors just to maintain what they had and wait out the award of the licenses till more fundraising would come in was constantly being jeopardized and impeded, seemingly as a way to just exhaust them and make them leave. If they give up, then they have no claim under the treaty or claim under the original licenses. And the bad acts in terms of unexplained shutdowns, reopenings with the exclusion of the claimant's property, claimant's concessions without differentiation or explanation, the failure to tag, so that in Mr. Amina's mind, the operations of NRD and the people operating it, presumably is what he meant, could be regularized. Well, what does regularized means? What he wants to see. So make him happy, the tags will happen. Without the tags, no money's flowing. What can happen other than at some point you exhaust the people holding the concessions and make them leave? That, we say, is all knowing violation of just basic minimum standards of treating an investor like someone who has an interest in the country that you're going to recognize and treat fairly. Next slide. And obviously expropriation. There were expropriation of certain aspects of the value of the investment, the flow of revenues from tagging, minerals that can't be sold. Now those minerals, they'll disappear, they go somewhere else. The tagging problem and the mistagging of problems associated with smuggled minerals from Rwanda was always one of the problems, and I'll get back to that in a moment. So it's the minerals are off, somehow getting to market, but not tagged in a way that the claimant's concessions share in any of that revenue for a prolonged period of time. Well, you could call that an expropriation, and there were events like that that expropriated certain aspects of the profits or revenues that would flow from the concessions while they were being held. But the real expropriation in terms of the value of the right occurred in March 2016 when the concessions themselves were resold by the respondent.
Could I ask for a little clarification on this point? I have no difficulty in understanding what you talk about, the real expropriation. Your claim, you say that you didn't appreciate until March 2016 that you were not going to get the 30-year long-term concessions that you contend your clients were entitled to. That I follow. But during the year 2012, there are a number of incidents that occurred of which you complain, which would have resulted in loss to NRD, individual losses, such as losses when they were unable to tag minerals for sale. Are you making independent claims for those losses, or is your claim for the deprivation, is your claim limited to a claim for the deprivation of the 30-year concession?
I'm going to answer that it's the latter, but the explanation is it's not as clean cut as one or the other in this sense. In the loss, the expropriation of the 30-year license, the right that they bought into to have the 30-year licenses awarded under the 2008 Act. The expropriation was a very long, slow process. Dangling the whole time, we're going to negotiate that with you. But it was a very prolonged and ultimately, in the end, intended not to issue the license, but to put in place first a law that would so-called justify saying no. And that treatment, that the expropriation by staying, not processing, then putting in place something and pointing to it and saying, well, now we get to take it back, winds up including throughout that time, if we weren't going to give up, if we were going to be able to maintain the concessions, the claimants had to continue to put a lot of money into maintaining operations, securing, etc. So expropriation isn't just on March, you lost, let's quantify, let's have someone come in and say, what's the value of those concessions on that day? It's bleeding them of all the money over the time. No question that amount that they have to put in goes up based on these events that cause costs, cause losses. But the expropriation was not a one-time event. If our claim is upheld, that means they had the right to those licenses in 2012. And they were bled for quite a long time until the entire situation could be repostured and then supposedly justified as saying, well, you know what, you're not actually going to get them at all anymore. And we say that significant losses were sustained as part of the expropriation over the period of time. I hope that answers the question. If I would say it this way, I think it's a clear answer this way. If in 2015, the powers that be that were encouraging Rod to stay the course, do not walk away, continue to press for the concessions, and this all may turn around, did turn around. Minister Amina was replaced at the time in my hypothetical. Concessions are awarded. Do I believe that under the treaty, a claim could be made that despite owning the concessions for the long-term value, being able to work, money was lost based on actions by the respondent that caused some seizure of property, some blocking of being able to profit and earn revenue from minerals and seizing of other property, which wound up in losses with the conduct of their agent, the person they worked through, Mr. Benzingi, or the person they allowed to act in such a malicious way, taking materials. I believe a claim could be made even with the concessions that constitutes expropriation of some value of the concessions, some property that was invested. And they would have to decide whether to sue just for that or not, and they haven't, they didn't. So as a standalone event, the seizure of the property and then return of the property, and now equipment's missing, now things are gone, the loss of profits over the period of time, there was no tagging, are not being sued upon independently. They are part of the sustained losses that went into a prolonged expropriation, through which time the claimants were losing money the whole time waiting it out.
Thank you very much. Does that conclude your opening submissions? If you need 10 more minutes, you're entitled to them because we ate into the time.
This is the last slide, and I will be brief. I think my intention all along was never to take the full time, and I didn't do a good job. That's my fault. I will just try to briefly summarize. The statute of limitations argument is one of the defenses come forward that says, well, regardless of the merits, regardless of how the dispute comes out as to who did what to whom when, sue too late. Well, the claimants did not sue too late. At least one of the claims only triggers in 2016, and the other claims trigger after 2015. Some point a decision was made not to issue the licenses But until then, the claimants were actually vying for licenses that could issue, and well within the statutory period. In terms of personal jurisdiction as to BVG, BVG made an investment in NRD before it completed the transaction with Stark selling the owner of NRD to the Spalena entity created to take the shares of the holding company. It already invested and started to plan for pursuing its mining interests through NRD. That's sufficient to trigger personal jurisdiction from BVG. Arguments about how much to quantify it, nitpicking about whether somebody saw every piece of property on the every asset on the list of properties that were invested in addition to cash, all of which goes to the second phase. We were asked, not only were we not required to quantify it in detail, we were told we couldn't. We're not here to present how big a loss all this was. So all we've done is show that BVG is a qualified investor. Spalena acquired the shares. BVG's money was put into it to make it happen, and it became a co-owner of Spalena. But even before, when Spalena first acquired the shares in the holding company, BVG was already directly an investor. In terms of subject matter jurisdiction, clearly that's a different way of spinning a legal argument on the same argument that the investment's not the right type of investment. Of course it is. You have to, I don't understand how any US investor, but through vehicles such as this, would invest in NRD, but for loaning it money to buy operations and pay for operations on the ground, putting in more capital so that big equipment could be purchased, et cetera. The same course would have followed when millions more were raised in future investment as planned with the long-term licenses, but it would have been the same vehicle and the same transaction. And that's the only way to invest in these mines for the US investors. In terms of consent to arbitrate, it's entirely superficial. It is entirely created for the purposes of this argument that anybody from the respondent ever asked for a distinction as to which hat Mr. Marshall was wearing. Spalena or BVG or NRD director now put on a different hat and talk about your managing investor role for BVG or Spalena. It's all artificial. Of course, they were. It was as the lead investor, as given control by his other investors of both investment vehicles, and as the director in charge of all operations of NRD in which their investment was being managed, Mr. Marshall was the only point of contact. So the idea that in response to BVG's notice, Rwanda, who decided it had no intention to talk to him about resolving his claims at all and let that pass, should have been told, and Spalena too, to the extent that the transaction that closed the purchase to acquire the shares of the holding companies in Spalena's name, wearing that hat, Mr. Marshall also invites you to resolve the loss of his investment based on these claims, then they would have discussed it with him in that hat. Is completely artificial. It is an attempt to say we could do everything wrong, but until you tick every box on which capacity you might be talking to us, we are not only going to not talk to you, but we're saying you're waiving your rights silently. This is clearly a challenge with no meaning whatsoever in terms of the purpose of the requirement for notice in the parties to try to resolve things without bringing it to this level. I apologize for going a little over what the stated time was, and I appreciate your patience throughout this argument.
Thank you very much. Mr. Hill, we'll go on until 7 minutes past for our time so that you make up the fact that you're starting a little bit late, and we'll shorten the next break by 7 minutes.
Thank you, Mr. President. We would submit that this is an unmeritorious claim that fails on its merits and also fails because of the preliminary objections to it that we have. I propose to deal with our points in that order, spending most of my time today on the merits of the substantive case, so I can give what I hope is a helpful guide to the evidential material you're going to see this week, and then say a little about some of our preliminary objections, which we suggest are also fatal. So beginning with the merits, as we sought to explain in our skeleton, at its heart, this is quite a straightforward case, and one where the merits are wholly one way and against the claimants. And all that one needs to do is go through the history of events, sorting the wood from the trees to see that. And what I hope, that's what I hope to assist you with today, and also in the cross-examination you'll see in particular of Mr. Marshall. And we would suggest that a lot of the picture from Mr. Cowley that you saw painted today did go some way beyond what the evidence in this case actually shows. Now, there's one key aspect of the claimant's claims and then a number of sideshow or subsidiary points. The key aspect of the case relates to the claimant's allegations regarding NRD's alleged entitlement to long-term licenses over the 5 concessions. Now, as you know, the gist of the claimant's case, and you've heard it again today, is that there was an assurance and a guarantee of long-term licenses on the strength of which investments were made, and that guarantee is to be found in the 2006 contract and also in various other assurances they say have been made. And the claimants then say that NRD made an application for long-term licenses in November 2010, and they say that while the licenses were not immediately awarded, the assurance of long-term licenses was reinforced by various extensions that Rwanda gave or indulgences allowing NRD to stay on in the concessions. And the claimants say that when NRD was not ultimately awarded licenses and in 2015 was told to vacate the concessions, that this amounted to an expropriation and breached the claimants' rights as investors in Rwanda through NRD under the Bilateral Investment Treaty or under customary international law. And by the time of the reply, this case has been, in fact, fleshed out with a somewhat absurd, we would suggest, a conspiracy theory, which does keep growing, and I'll come back to that. Now, none of that case has any substance. We would highlight 11 points at the outset. First, there was quite obviously no guarantee of long-term licenses in the 2006 contract. NRD was given a right to 4-year licenses, and as you'd expect, any expectation that this would then lead to long-term licenses depended on NRD fulfilling its obligations in the 4 years and then delivering a satisfactory feasibility study to prove to the government's satisfaction that it was deserving thereafter of long-term licenses. Secondly, there were no assurances outside the contract that NRD was automatically entitled to long-term licenses or anything like that. And we will go through some of the sources for these assurances that have been identified by the claimants in their memorials and identified by Mr. Marshall. And there is nothing in any of them. Much of it consists of what we would suggest is a grotesque misreading of certain of the documents in the case. And it's worth remembering that Mr. Marshall was not on the scene at all vis-a-vis NRD when the NRD contractual relationship with the government started in 2006. He didn't arrive as regards NRD until late 2010. There's no evidence whatsoever of any assurance before his arrival, and all the evidence is to the contrary. Now, Mr. Marshall, I would say, did have previous form in running, unsuccessfully, a concession at Bisesero, which had been granted to Bayview Group. The license to that concession was not renewed as a result of BBG's underperformance, and no complaint has ever been pursued that that was unlawful. So Mr. Marshall cannot seriously suggest he received any assurance in that capacity either, even were that relevant. Thirdly, when Mr. Marshall's company, Spalena, purchased NRD for just at the end of 2010, he knew that there was no assurance of a long-term license. And indeed, he was specifically told that NRD was unlikely to obtain long-term licenses. What he was told correctly was that the level of exploration, resource estimation, and industrialization done by NRD had fallen far short of what was expected of any operator looking for a long-term license, and the most that NRD could hope for would be a renewal of 5-year exploration licenses to give them a chance to do what they should have done in the first 4 years, but even that was uncertain. Fourthly, when NRD applied for a renewal of its licenses shortly before the expiry of the 4-year terms, they didn't even apply for long-term licenses. Because of the limited exploration and industrialization work that had been done, NRD knew that long-term licenses were out of the question, and they applied for a renewal of 5-year licenses. And it's worth looking at paragraph 18 of the claimant's pre-hearing brief on this, if that could be pulled up.
Yes, I can pull that up. Can you help me? That's in the pleadings.
It's, I don't know, I'm afraid is the answer to that. They were filed on Thursday, last Thursday. I don't know where. It is, I'm afraid, just worth taking a moment because I've got 1 or 2 other references to this document. So, so it would be helpful if it could be
I will look
located.
for that amongst the files that I have access to.
I don't believe it is with FTI, given it was just filed, but I can get it to FTI. It will take a few moments.
Ms. Doman's got a hard copy. I've got a hard copy, which I will share, and so we can proceed straight away.
I'm very grateful. In paragraph 18, what's said in the second sentence is the contemporaneous evidence demonstrates the respondent represented the claimants that it intended to negotiate the terms of a long-term licenses of claimants based upon the application submitted. Respondents after the fact characterization of the parties' discussions cannot change the fact that the understanding at the time was that the claimant's application, styled as a 5-year extension, was for a long-term license of the concessions. Now, it's difficult to know what's meant here. There is no contemporaneous evidence at all demonstrating that the respondent represented that it intended to negotiate long-term licenses. And it's right to say the application was styled as a 5-year extension. And that is because it was indeed an application for a 5-year extension. And what is more, Mr. Marshall knew that a 5-year extension was all that had been pitched for when he arrived on the scene to acquire NRD at the end of 2010. And all of that of itself shows that the case here that there was an expectation of long-term licenses is, in my submission, hopeless. And just pausing here, it's worth just staying with paragraph 18 to get something of a flavour of the claimant's, the way the claimant's submissions operate. The next sentence says, claimant's principal, Mr. Marshall, was told by respondent that the application would be considered for that purpose. There is no evidential basis anywhere for that assertion, not to be found in any witness statements. I don't know if we're going to see something coming in by way of evidence in chief. We'll have to see. The next sentence, this is confirmed by the fact that respondent granted an extension of NRD licenses in order to negotiate the terms of a long-term license. And then NRD did in fact begin negotiating the long-term license of Dominique Bodega, the then acting director of OGMR. Now, there's nothing in the extension letters, any of them, which suggest that the respondent granted an extension to negotiate long-term licenses. That is just an invention, and we'll be looking at the extension letter that's referred to, and indeed other extension letters in due course. The reference to Mr. Bodega is something different. That relates to a curious episode which happened in late 2011, which we'll be referring to later. The claimants refer to it a lot. And all I would say at this point is that that episode of Mr. Bodega does not assist the claimants at all. My fifth point is that the November 2010 application for renewal of the 5-year licenses was itself thin and unsatisfactory. The lack of progress made by NRD in the 4-year period and the paucity of the exploration and sampling work and the evaluation of the mineral reserves that was required was obvious on the face of the application. And NRD knew at the time, and Mr. Marshall was told when he bought in, that this application was inadequate even to justify the 5-year licenses being sought, and very, very far short of what was required to justify long-term licenses. Sixthly, NRD was notified in August 2011 that it had not complied with its contractual obligations. And following that, there were no extant rights of any kind in respect of long-term licenses arising from the contract. Seventhly, the licenses themselves expired in January 2011. They were extended consensually until October 2012 to allow for further negotiations between NRD and the government. And after that, there were no further extensions, although the government did, as a matter of indulgence, make temporary allowances for NRD to remain on the concessions while they applied for new licenses. And the point here is, again, that none of these extensions or allowances ever conferred any right or expectation to long-term licenses or involved any assurances or anything of that kind. And the repeated refrain that they did is, in our submission, untenable and derives from at best from a misreading of the documents. And related to that, we would say on our side that the fact that the government did keep making allowances so as to give NRD a chance to make an adequate application for a license is in fact inconsistent with the claimant's case theory, and in particular their extravagant case theory about there being a conspiracy to oust NRD from the concessions. If there was such a conspiracy, the government would never have been as indulgent and generous as it was. And what you will see in the evidence is that instead of being harsh on NRD, the government in fact gave NRD chance after chance after chance. Now, while we're on assurances, we have an enhanced story developed by the claimants in their skeleton at paragraph 10 of the document, and we heard more of it today. And this is about personal assurances being given to Mr. Marshall by people in the military with whom he says he worked. Well, it's worth noting that what's said at paragraph 10 about assurances from the direction of the military, which it says at the end of this paragraph, while simultaneously reaffirming its guarantees and continuing negotiations towards the promised long-term licenses, which included assurances from the Rwandan military who valued Mr. Marshall's services. As long as he remained patient, NRD would obtain the long-term licenses. Well, that is not in Mr. Marshall's witness statement and goes well beyond what is in Mr. Marshall's witness statement. And it's hard in any event to understand the relevance that some conversation that Mr. Marshall now says he has with someone in the military to his application to the Ministry of Natural Resources for new licenses. Those applications and any application made obviously need to be considered on its merits, and it would be odd if it wasn't. And one gets a similar point at paragraph 31 of Mr. Cowley's skeleton, pre-hearing brief, where he again makes a new evidential point, not in the evidence, about assurances from the military. And we heard more of it in the submissions, the oral submissions today, at the outset of the claimant submissions, some of the first points that were made today, and referring to Mr. Marshall as acting as a voice for the military. Again, that's a new point, not in evidence, and we suggest irrelevant. And it seemed from part of that submission that the claimant's case didn't seem to be that the claimant should have received fair and equal treatment. They appeared to be suggesting the claimant should have received some special treatment that other investors didn't get, as a result of some personal relationship that Mr. Marshall had with the military, not the proper subject of a claim of this kind. Now, my 8th point is that throughout the period of the voluntary extensions to the licenses and the ad hoc indulgences thereafter, that's after October 2012, NRD had every opportunity to put in a compliant and adequate application for long-term licenses if it was able to, but it was unable to, and its attempts were weak and unprofessional. And specifically on those points, what you'll see in the evidence is that after the inadequate November 2010 application for renewed license, there was an extremely feeble application for long-term licenses in January 2013. That had no real substance at all, and NRD could never have expected it to have any real chance of being adequate. And it was interesting to see that that wasn't even mentioned today in the submissions. Thereafter, given that the licenses had expired in October 2012, NRD had to be, in fact, chased by the government repeatedly to apply for new licenses. And again, that all gives the lie to the conspiracy theory of the government trying to get them out. Mr. Immoner specifically chased NRD repeatedly in late 2013 and then repeatedly in 2014. And eventually, in late 2014, the NRD did apply for licenses. They did at that point apply for long-term licenses, but the applications were again palpably deficient. And there was nothing, in particular, there was nothing of substance that was additional to the applications that were themselves weak when they were made in 2010. My 9th point is that it was unsurprising that the license applications after 2010 were unforthcoming, and that when they did come, they were deficient and didn't add materially to the original November 2010 application. And the reason for that is that after Mr. Marshall and Spalena arrived at the end of 2010 paying, they made no material further investment into NRD, either in industrializing the mining on the concessions or in exploratory work and evaluating the reserves. What they did do instead was to allow artisanal mining to carry on in the NRD concessions and make money out of buying the minerals dug out by individual artisanal miners. And as a result of all that, NRD post 2010 was never going to be in a position to make a more impressive application than it had made in 2010, because it simply wasn't putting in any work or investment to improve the position it was in by carrying out further proper exploration or taking further steps to industrialize. And related to that, what we actually see on the evidence is that, if anything, matters deteriorated under Mr. Marshall's watch rather than improved. The financial condition of the company worsened, with debts owed to trading partners, to employees and the revenue. And for example, NRD could never have secured long-term licenses without a revenue clearance certificate. But it was in fact running up debts to the revenue which were unpaid and indeed the subject of enforcement. And given its debts to the revenue, it could never have obtained the relevant tax clearance that would have it was a necessary part of any license application. And it's not just the finances of the company, although those are important. NRD, under Mr. Marshall's watch, also permitted illegal mining, or at the very least was unable to prevent it because of management failings and failure to invest in sufficient security. And the combination of illegal mining and NRD's own activities also meant that there was continual environmental damage. And it's also worth keeping in mind here that Mr. Marshall's whole scheme was evidently to try to secure long-term licenses, mainly by applying political pressure or bullying, as we'll see in the correspondence, without actually investing in order to obtain them. And what he wanted to do, and he's actually quite candid about this in one of his witness statements, is obtain financing after and on the back of the long-term licenses. But the problem with that is that the 2006 contract and the scheme of the government's mining policy, published in early 2010, simply don't work that way, as Mr. Marshall should have known, and must have known, we would say. The purpose of the initial short-term licenses was for the concession holder to commence industrialization and undertake proper exploration work. That requires investment, and that was necessary in order to justify the long-term license. So you had to invest upfront, and that's why the Zarnak's original business plan, right back at the beginning of the NRD contract, envisaged as much as 39 million of investment. In fact, it would be generous to think that even a third of that was spent, even on NRD's own figures, as contained in its 2010 November application. So Mr. Marshall's business strategy of securing licenses without long-term licenses, without spending or sourcing investment to do so, could never have worked. Just as an aside, in relation to that 39 million figure, this morning, Mr. Cowley referred to C014, which is a document that he said suggested a 39 million investment. Now, the impression given in this morning's submissions was that somehow that investment might have been made in NRD. If that suggestion was meant, it was unfortunate. That reference to 39 million in C014 is quite obviously a reference to the original projected investment put forward by the Zarnaks in the business plan under which the 2006 contract was granted. I had thought it was common ground, and all the evidence shows it, is that only around a maximum of $13 million, even taking the claimant's figures at face value, was in fact invested during the Zarnak and Stark era. And the claimants have never suggested previously that $39 million was invested, and it's inconsistent with what they have suggested. So I hope that wasn't the submission that was really being advanced. My 10th point is that the government behaved both fairly and indeed generously to NRD in dealing with the license applications when they were made. When the 2014 applications were made, they were evaluated objectively by a team of people who gave a sensible and rational recommendation to the minister with reasons for why the application should be rejected. Moreover, NRD was specifically told in late 2014 and 15 what was deficient or missing in the 2014 applications, and was given 3 opportunities to submit additional documentation. Those opportunities were met with a feeble response from NRD, and as I've stated, NRD's own deficiencies meant that it could never have put in an adequately compliant license application, although it's fair to say its efforts to address the problems were meagre. 11th point, when the government finally declined the license applications in mid-2015 and thereafter put the concessions out to tender, it was fully justified in doing so. This wasn't an expropriation of any kind at all. The licenses themselves had in fact expired a very long time previously, in October 2012. NRD was at that point only continuing to occupy at all on a temporary indulgence to give it the opportunity to make an adequate application. It was unable to do so, and once the license applications were determined against NRD, it was entirely right that they should leave the concessions as unlicensed operators with no contractual or other rights to occupy or exploit the concessions, and of course entirely right that the concession should be put out to tender. So we would submit that those are the essential points on the key area of the case that you will see from the evidence as it emerges this week. And once the facts are seen and understood, they speak for themselves, and there isn't in our submission a shred of a case here. Now, one thing that summary I've just given doesn't get across is the flavour of the communications by which NRD and Mr. Marshall carried on their business. What you'll see time and time again is that the individuals in the ministries on the Rwandan side doing their job, writing straightforward, sensible, professional letters to NRD. But as they did so, if there was anything that smacked of criticism of NRD or even thwarted Mr. Marshall's plans in any way, what one sees is the most extraordinary response from Mr. Marshall. There is letter after letter in which Mr. Marshall, on the flimsiest pretexts, launches into allegations of expropriation and even of corruption and criminality on the part of ministers and others. In my submission, the tribunal will have to assess for itself what Mr. Marshall was up to with some of this extraordinary correspondence. It is truly littered with distortions of reality. And you'll also see that the letters are copied to a number of people in each case, including various other ministers and usually the US ambassador. Now, we would submit that on any view, Mr. Marshall was seeking to lay a paper trail by his misleading account of things, and in particular for a future arbitration of this kind. But he was also, it appears, seeking to bully and pressurize ministers with the tenor of his correspondence. And we do say that the overall effect is something that is remarkable to see in the business and commercial context. It's a long, long way from the behavior you'd expect from any serious professional applicant for a mining license. So that's the main area of the case. There are also a number of sideshow or smokescreen issues, and they are issues thrown up by the claimants, it looks like, in the hope of muddying the waters. And I'll just run through the main ones briefly. The first is a long and convoluted episode involving Mr. Benzingi. So he was one of the original shareholders of NRD. He founded the company along with the Zarnax. He took issue with the sale of the shares by the Zarnax to the Stark, HC Stark, and in consequence, as a result, took issue with the on sale to Spalena. Mr. Benzingi challenged the legitimacy of the appointment of Mr. Marshall and Ms. Moroskova, which resulted from their acquisition of shares. And there are two episodes that the tribunal will see involving Mr. Benzingi in this case. None of them actually adds anything to this case or could conceivably give rise to a realistic claim. The first one was something that happened over a very short period of a few days in August 2012. Mr. Benzingi managed to persuade staff at the RDB, the Rwandan Development Board, which deals with public company registration, that he managed to persuade them that the correct position was that he should be registered as director on the records rather than Mr. Marshall or Ms. Moroskova. Within a very short time, a day or so, Mr. Marshall complained to the RDB. The matter was then taken up by the RDB, who dealt with it promptly and professionally. Within 3 days, Mr. Benzingi had been suspended from acting as director while the RDB investigated. And within a further 1 day, the RDB directed the return of company property to Mr. Marshall. So it was a problem that lasted a few days and where the evidence plainly shows the RDB acted honestly, impartially, and fairly. The claimants complain about the actions of Mr. Benzingi and things that he did in that short period, but those, of course, are the actions of Mr. Benzingi as a private individual and cannot conceivably ground a claim in an arbitration of this nature. And just to give, again, a flavour of the way the claimants are trying to present this case in this arbitration, it's worth taking up the pre-hearing brief again at paragraph 19. They say in relation to this August 2012 episode, claimants, Mr. Benzingi had no role in the company. Claimants could not have known it at the time, but this was one of the first bad acts in a long line of bad acts perpetrated by respondent in an effort to force claimants to abandon their investment. Now, 2 points about that. First, Mr. Marshall accepted at the time that the RDB personnel who were initially persuaded by Mr. Benzingi to change the registered information were not in any way collusive or acting in bad faith. They were just persuaded by the information given by Mr. Benzingi that this was the correct thing to do on behalf of the company. Secondly, once this difficulty was escalated, because there was a dispute between the shareholders about it, there was a very prompt investigation and obvious neutrality and professionalism shown by the RDB. And I would submit that this sentence about it being a bad act and a long line of bad acts is an untenable characterization of events. And it does demonstrate the kind of way in which the claimants are putting this case that we will all have to wade through. Now, back to Mr. Benzingi. He felt aggrieved at losing that first round, and he pursued his arguments later in 2012. And he did so by launching an arbitration involving him and NRD, which was subject to various inter-parties court rulings at the early stages of identifying the arbitrator and the like. So just to flesh out that point, it's not as if this was some private arbitration that the NRD or the claimants never knew about. They were actually involved in the arbitration at an early stage in various court hearings dealing with the constitution of a tribunal.
Could I just intervene? Because I've been very puzzled by this particular proceeding, an arbitration in which an individual challenges a company as to who is the correct chief executive of the company. It seems to have its origin in a court order, and I find it difficult to identify any comparable civil proceedings in this country. One would have thought it would be some kind of proceeding under a Companies Act. But we've got very tenuous evidence about this, both from the claimants and the respondents.
Well, we have some evidence on it from Mr. Mugisha. Rather than shooting from the hip, I might make sure I characterize it accurately and come back to you on that, just so that I make sure I'm making the correct submission.
Thank you.
What I think I can say, because my recollection on this is, I'm sure, is accurate, that both parties were, both the NRD side or the claimant side, I should say, and Mr. Benzingi were consensual about there being an arbitration. I think there was a falling out, and this is the subject of the court hearings, about how the tribunal should be constituted. The claimant side wanted a 3-man tribunal. Mr. Benzingi wanted a 1-man tribunal. Initially, the claimants were successful, and then Mr. Benzingi was successful in various rounds of court hearing. But as far as I recall, there was no problem from either party about this being dealt with by an arbitration rather than by some court proceeding. So that resulted in an arbitration held in April 2013. It's clear, and it's clear from the subsequent appeal judgments, that NRD was duly notified of the arbitration hearing, but they chose not to turn up to it. And they chose not to turn up to it by writing a letter on the day before the first of the arbitration hearings, objecting to the arbitrator, but not taking any other steps other than writing one letter to the chairman of the arbitration centre, which in our submission falls far short of the steps that should have been taken if that was a challenge they wanted to pursue. In the event, there was a arbitration hearing, and that was a substantive hearing. It wasn't a default hearing or anything like that. It was a hearing on the merits, and the Benzingi's claims were determined in his favour. And Mr. Mugisha deals with the consequences of that, which is that the shareholdings reverted to the position that they were before the transfer by the Zarnax, and that meant that Mr. Benzingi could pursue his claim that the shareholdings should revert back to the original position. He would still obviously only be a minority shareholder, but the shareholdings would revert, and that subsequent resolutions consequent on the subsequent transfers of shares were invalidated. Now, NRD appealed that, and their appeal was rejected at 2 levels of appeal, the final Supreme Court decision being given in May 2014. Now, it's important to note in relation to those appeals that the claimant's submissions in this case, and it was a point flagged up in that letter I mentioned, is that the arbitrator was in some way conflicted or biased. If that were the case, then the claimants would indeed have had, as NRD would indeed have had, a valid ground of objection to the arbitration award. But that is not a ground of objection they in fact pursued on appeal at either level of appeal. It's something they've brought up in these proceedings, and it wasn't a point they took at the time or pursued at the time. Now, on the back of that award, sorry.
If that award was correct, wouldn't it follow that Spalena has no locker standi of any kind in this arbitration?
Well, it certainly could follow. That's the implications of Mr. Mugisha's evidence. And we've
It's
always
a more
said,
fundamental point than any that's been taken.
well, we've certainly not accepted. If you look at our post-hearing briefs, we've certainly not accepted, but they are proper shareholders for that reason. Now, on the back of that award, confirmed by the Supreme Court ruling, Mr. Benzingi made various attempts to enforce his award. The claimants complain this resulted in NRD being shut out of their Kigali office and parts of their concessions at the time. And none of those points take the claimants anywhere. Mr. Benzingi had the rights that he had under his award and the Supreme Court judgment, and the bailiff who he instructed also had his professional rights and obligations to enforce the judgments. And the claimants haven't, in our submission, advanced any coherent case that the bailiff, Mr. Bosco, who's going to be a witness, exceeded his rights and duties in any way. But even if he had, none of that involved actions of a state or participated in by the state in any way. And the claimants do suggest that this episode is relevant on a different area because Mr. Imina, the state minister in charge of mining, was unwilling to issue tags for minerals to NRD in part on the basis of Mr. Benzingi's claims. And we heard more about that this morning. 2 points on that. First, the reason why Mr. Imina refused to issue tags for minerals was in fact twofold. One of the reasons why tags were not issued by him to Mr. Marshall was that tags were only supposed to be given to licensed mining operators. And we have other evidence on that. NRD did not have a license. And despite repeated requests from Mr. Imina to apply for one, they hadn't done so at that stage. So it was quite right for Mr. Imina to say, you are an unlicensed operator. I've been trying to get you to apply for licenses repeatedly. You must now apply for licenses, and I'm not going to allow you to keep receiving tags as an unlicensed operator and benefiting from them without making the application you should make and which you're required to make under the scheme.
My understanding is that NRD were given informal permission to act as if they had a license. Is that correct?
They were given informal permission to remain on the concessions, but subject to the fact that from October 2013 and then repeatedly in 2014, they were being pressed to apply for licenses and were declining to do so. So in our submission, it was entirely fair for the person issuing tags to say, I'm not going to give you the indulgence of treating you as licensed, keeping on treating you as licensed pro tem while you make an application when you're not in fact making this application.
Yes, I would be grateful at some stage for a bit of further assistance with the status that they had under these informal permissions that were granted.
Yes.
But you needn't deal with that at this point.
I'm grateful. Well, I mean, I can just foreshadow what will be said, which is these were not by any means formal licenses. They were indulgences. And to take tagging as an example, they should have had proper licenses, which they were being asked to apply for. And it went beyond the scheme of the policy to be granting them tags when they were not licensed. That was very much an indulgence and entirely proper and right to say, you must now get a license and I'm going to stop giving you these tags until you do. So that was the first reason from Mr. Imina. And the second reason was that he was faced with competing claims from Mr. Benzingi and from Mr. Marshall for being the people who are entitled to represent NRD and receive these tags. And in fact, he was being threatened with being sued by Mr. Benzingi. So in those circumstances also, fair enough not to issue tags and not to take sides. And we don't accept the suggestion from the claimants that Mr. Imina was siding with Benzingi. He wasn't, he was standing in the middle. Now, just on all those points, we do say that you'll notice in the contemporaneous approach by Mr. Marshall, and also in the claimant's case, that they repeatedly underplay the fact that Mr. Benzingi had the benefit of this arbitration award backed by the appeal judgments, and which supported his claims in respect to the management and ownership of the company. So to take, for instance, going back to the pre-hearing brief, if one goes to paragraph 26, they say Mr. Imener's argument that there was a dispute over NRD's ownership is unfounded and outrageous. Mr. Imener casually admits that upon threats from Mr. Benzingi to sue Mini Rayner, he decided to prevent NRD from receiving mineral tags. This is an astonishing admission. He blocked claimants' ability to operate their investment upon the mere threat of litigation by a Rwandan national. It wasn't a mere threat of litigation by a Rwandan national. Mr. Benzingi had the arbitration award and a Supreme Court judgment which supported his position, although you might not have appreciated that from this paragraph. The claimants then go on. Any issue over ownership had already been resolved in Spalena's and Mr. Marshall's favour when Mr. Benzingi tried a similar trick. In 2012, the RDB expressly recognised Spalena's ownership of NRD and that Mr. Marshall was the managing director. Mr. Marshall provided Mr. Imener RDB's registration information and informed him that Mr. Benzingi, working with a court bailiff, blocked claimants from NRD's offices and confiscated NRD's properties on June 13, 2014. Mr. Imener's contention was unaware of such activity is false. Now, there's a bit of unfortunate sleight of hand here. Whatever the RDB decided in 2012, that's referred to in there, was of course before the 2013 arbitration award and before the 2014 Supreme Court judgment. So whatever the RDB thought in 2012, Mr. Imener was entirely reasonable to see the position as disputed and one in which he needed to see a resolution and to consider it would be inappropriate for him to take sides. Then in paragraph 28 of this pre-hearing brief, the claimants say, by Mr. Imener's own admission, he was using the tagging system as a political tool to harm a foreign investor. That is a quite unfair spin. Mr. Imener was acting for these two reasons that I've suggested, and the claimants haven't even dealt fairly at all with the first reason, which is that the tags are for licensed operators and that NRD had declined to apply. And we do say that Mr. Imener was entirely justified in the approach he took to tagging. And we will also say, and it will be apparent from some of the correspondence we'll go to, that at the time, Mr. Marshall very significantly ignored or underplayed the fact that Mr. Benzingi had this arbitration award from an arbitration that the NRD had chosen not to attend and had it backed by appeal court judgments. So that's the Benzingi episode. The next episode or set of episodes relates to Mr. Bosco Nsengiyuma, and he's the professional bailiff. Now, Mr. Bosco is a highly experienced bailiff. During the period of which this arbitration is concerned, he was involved in executing a number of judgments against NRD. There was first an unfair dismissal claim, then there was Mr. Benzingi's judgment, and there were also judgments from employee claims against NRD from some 25 employees. Now, the ins and outs of the various enforcement processes from Mr. Bosco are lengthy. We would suggest they're immaterial to this case. Mr. Nsengiyuma, Bosco Nsengiyuma, has put in 2 witness statements which explain his actions in detail, and we will suggest that he's clearly an experienced professional bailiff, clearly doing his best to comply with his duties faithfully and executing on lawful judgments. And this is another area of the case where we suggest the claimants simply don't like what was happening and leap to theories of conspiracy or corruption, where the short point is that there were judgment debts because NRD was in default and had not paid its debts, and there was a bailiff who was entitled to execute on those debts and was doing so. And as I say, there are a lot of ins and outs, and for an accurate account of the detail, I would commend to the tribunal the detailed explanation that Mr. Bosco gives in his 2 witness statements. We would also reiterate the point that in any event, his actions cannot be attributed to the Rwandan government. Now that brings me to the third sideshow point, which it relates to the conspiracy theory advanced by the claimants involving smuggling minerals from the DRC and selling them as Rwandan minerals. And it's difficult in our submission even to understand the theory. It was set out somewhat vaguely in the claimant's memorial. It grew in the telling by the time of the reply, and now involves an unnamed oligarch who at an unspecified time and in an unspecified way may have wanted NRD to assist in smuggling, which Mr. Marshall says they did not do. And in some other unspecified way, it's then said that the expropriation that Mr. Marshall says has occurred is in some way at the behest of this unspecified oligarch. Now, there is a total, and I mean total, absence of evidence to support this case. There is also a total absence of sufficient detail even to understand it. But even if those points weren't themselves fatal to this conspiracy theory, the case is evidently nonsensical. First, and most importantly, we can actually see from all the evidence what in fact happened to NRD's applications for long-term licenses. We can see who was involved, and we can see what they decided and why they decided what they did. This was a contemporaneously documented, transparent process. It involved teams analysing the applications, explaining why the applications were deficient, and such that it should never have been any surprise that NRD didn't make the grade. Mr. Marshall had, of course, been told of the problems in 2010 when he bought into the company and hadn't improved on the position in the years that follows. Secondly, on this conspiracy theory, to the extent one needs to even think about it, one can see that the underlying premise is untenable. Rwanda has, in fact, well-observed and thorough processes in place for preventing smuggling and is a main proponent in the region of measures to prevent smuggling. And so while no systems can be foolproof, there's no conceivable basis for any suggestion that Rwanda is promoting or even condoning smuggling. It does the opposite extensively and as observed by third-party partners such as the representatives of the Tin Council Initiative. And it could never be in Rwanda's interest to condone smuggling, and it does the very opposite. Thirdly, the only material that the claimants seek to rely on, and they do so inferentially to support their theory, is various bits of data or statistics which the claimants suggest show that more minerals are exported than are produced. Well, the data doesn't in fact show that. They've misinterpreted it or drawn incorrect inferences from the data, and this is a misguided exercise, and that's dealt with by our witnesses. So if you turn to the claimant's pre-hearing brief again and look at, for instance, paragraph 13, one can see sentences like the claimants did not and would not participate in smuggling, and therefore NRD was singled out and treated differently in violation of the bilateral investment treaty. This is, in our submission, simply an allegation not anchored in reality and with no evidence. The next sideshow issue relates to the fact that from time to time, NRD was made subject to requirements to cease mining in parts of their concessions because of local issues arising from illegal mining and environmental problems. And the short point here is that there were indeed problems from both illegal mining and environmental issues on NRD's concessions. These problems got worse over the period in which Mr. Marshall and Spalena was in control. And one sees in Mr. Marshall's protestations at the time, and this is repeated by the claimants, that allegations that NRD was not being fairly treated. But that is unfair, again, on the claimant's part. On illegal mining, what they say is that Rwanda should have prevented illegal mining on NRD's concessions. That's a bad point, and it's not how it works. The duty to prevent illegal mining on the concessions was the concession holders, NRD's. And if they couldn't do it, if NRD couldn't do it, that was a function of them having areas of concessions that were too large for what they could cope with, but they simply weren't working themselves. They were leaving unprotected. and simply too large for the scale of operation and investment that they were engaged in. And indeed, NRD recognized that it was their responsibility at the time, because eventually they promised to do something about it by hiring demobilized soldiers to help police the concessions. And when they did so, when they promised to do so, they were permitted to work again on the concessions. So no unfairness there. On environmental issues, the claimants repeatedly said and say that the environmental damage in the concessions was not NRD's fault, because it was the fault of the illegal miners or an environmental hangover from colonial mining practices by the Belgians. But neither of these points, in fact, wash. The illegal miners should themselves have been prevented by NRD, as I've just mentioned. And the point about colonial practices is an exaggeration, because what was in fact discovered was that NRD's work and its failure to control illegal mining was exacerbating the environmental issues. Even though I'm sure it's fair to say there was some original hangover from the colonial period, but the problem was that whatever damage was done in the colonial period was being exacerbated by the way in which the mines were still being exploited during the period of NRD's control. Now, the last sideshow issue relates to the allegations that other operators, and in particular Tinco and Rutungo Mining, were in some way treated more favorably because they didn't end up with long-term licenses. And there's nothing in this either. Quite simply, they were justifiably regarded as having made strong applications because they were some of the best performing mining operators, unlike NRD. And the documents show at the time that Mr. Marshall regarded them as having 20 times NRD's productivity on much smaller concessions. These companies had made properly substantiated, timely applications for long-term licenses, unlike NRD. So there's no surprising or unfair differentiation in treatment. Relatedly, there's an allegation about another company called Ngali Mining you may have come across, and that's again focused on by the claimants now. But again, the claimants don't begin to establish that Ngali Mining is in a materially similar situation to NRD. So you've got the starting point for some relevant differential treatment by reference to the National Treatment Standard. Ngali Mining was in fact a gold miner. It had been granted licenses to mine a different mineral, gold, to that which NRD mined, using different techniques against a totally different contractual background, and indeed in a different period several years later under a new 2018 mining law. So there's just no relevant comparison in order to conduct any useful exercise. So those are really the issues in the case that we will be covering. And I've given you a cross-section of them by reference to the issues. What I was proposing to do, and perhaps now would be a good time to break, is give you a cross-section of the case in a different way, which is chronologically, just trying to divide the period into blocks of time, and just to tell the tribunal what particular milestones or points that are likely to be covered in the evidence are to be looked out for in each block of time, which I hope will be helpful.
Thank you. We'll break now, but we'll break for 40 minutes, not 45 minutes.
Okay, everybody, I'm going to go ahead and open up the breakout rooms. Absolutely. Closing the rooms now.
The tribunal connection is muted. When we return from the breakout room, it defaults to mute.
So I'm going to ask to unmute, and somebody's going to need to. There you go. Thank you so much. All right, great. Mr. President, can you hear us?
I can.
Excellent. Okay, I'm going to go ahead and go off camera.
Hello, Mr. Hill, ready for you?
I'm grateful. I'm sorry I didn't hear you, Mr. President.
We're now ready.
I'm grateful. But just before I resume, could I just mention that unless, as far as I'm aware, we haven't had the email of the Mr. Ehlers and the cooperation agreement email. Apologies if it's sort of in the ether as I speak, but we really must have it. And I wonder if Mr. Cowley could tell us if it's in fact coming.
It's coming. It's what we've been working. Well, I'm not going to take any credit for working on it. It's what Mr. Harrison has been working on during the break while trying to also eat something. So yes, it's on its way.
On its way.
Thank you. So I was going to do a more chronological cross-section now, taking the period of the case in a series of blocks. The first block or era would be what one might call the Zarnak era, and that covers the period from 2006, when the Zarnak and Mr. Benzingi incorporated NRD, through to 2008, when the Zarnak sold to HC Stark, a mining company. Now, in that first period, there was obviously the contract, which was issued in November 2006, and the 4-year licenses, which were subsequently issued. And it's just worth pulling up the contract briefly. It's at C017. And I would submit it was quite telling that this morning, Mr. Cowley didn't spend any time on the contract, even though it's said to be where there's a guarantee of rights to a long-term license. And if we look at page 1, we can see from Article 1 that there is a 4-year period, 4-year term of the contract. In fact, I'm not sure, thank you, FTI, I'm not sure it needs to be blown up unless anyone particularly wants it. I think one can see from the full screen. So there's authorization for 4 years. And there are then a series of obligations starting in Article 2, which are obligations on NRD. Now, these obligations amounted to conditions to obtaining a long-term license later, as Mr. Mugisha explains. Thank you very much. And just in that context, it's worth noting that Article 5 always provides for the ability to terminate for breach of the obligations. And Mr. Guattari, in his witness statement, has explained that a number of these licenses were issued as part of the privatization of mining, the goal being to improve production and move away from artisanal mining, which can be as simple as individuals with picks and shovels, towards a more industrial model. And the idea of the 4-year license was for the private investors to prove themselves as serious operators, so they were to commence industrialization and, importantly, conduct exploratory work and evaluate the mineral reserves so that at the end of the 4-year period, they could produce a feasibility study. And the government needed to be satisfied about the adequacy of the information and the proposals in the feasibility study, including the resource estimates and the exploratory work done, before it would grant a long-term license. And you can see this reflected in the contract. So Article 2.2 provides for the provision of an investment plan, as well as an environmental protection plan. And in the case of the Zarnaks, that was the one that resulted in a $39 million proposed investment over the 4 years. Article 2.3 then provides for the party for the concessionaire to move to industrial exploitation immediately. In other words, as per the government's strategy, don't just continue with artisanal mining. And that is unfortunately what NRD very largely did, because just jumping ahead, in 3 out of its 5 concessions, on any view, there was no industrialization of any kind at all. In 2 of them, there was very limited infrastructure work, which I will come back to. Article 2.5 provides for evaluation reports of the reserves. So that would require substantial exploration, drilling and sampling and the like to evaluate reserves. And what's also required is a feasibility study after 4 years. Now, we've seen this reference to a feasibility study. It's worth understanding what a feasibility study is. And this arises because we fully accept that there was some accompanying material with NRD's November 2010 application. and indeed its 2014 application. And the claimants say that this amounted to a feasibility study as required by the contract. Now, we would suggest it's worth looking to see what Mr. Immoner says about that. He is a geologist. He became a state minister of mining, and in his supplemental statement, he explains at paragraphs 13 and 14 why the material in the November 2010 application did not amount to a feasibility study or indeed an evaluation of reserves as required by the contract. So if we'll come back in a moment to the contract, but if FTI could pull up Mr. Immoner's supplemental witness statement, I'd be grateful. And it's paragraphs 13 and 14, where he says he explains further why the November 2010 application, that's fine. So first, the report NRD provided talks largely about gathering already existing information, desktop study, giving an introduction to geology and mineralization, setting out achieved production and providing some information about remote sensing. This kind of information is simply a preliminary description of the concessions and a summary of what NRD produced in the previous 4 years. It is not a feasibility study for a professional industrial mining project as was required under the contract. A feasibility study for an industrial mining project should be a comprehensive and detailed document that contains, among other things, the study of geology, geophysical and geochemical studies, geological, geophysical and geochemical maps, the ore reserves as per standard definitions, the mineral reserves models, geotechnical studies, studies on environment, studies on infrastructure, studies on markets, the mine design based on the mineral reserves models, the mine section, the mine plans, the mining methods and extraction sequences, the ore handling processes, the results of metallurgical tests, the process design, plant design and flow sheet, the mine construction budget and schedule, the production schedule, the capital and operating cost estimates, the cash flow study, the financial evaluation and risk analysis. NRD report did not include any of that. Now, I'm not going to go into NRD's report at this stage, but I'll be doing that in due course. But that gives you a picture of what one would be expecting to see in a serious application for a long-term mining contract. And NRD never came close to producing a study of this kind. And as I say, Mr. Marshall was warned when he bought into this project by NRD, the existing people at NRD, that the work just hadn't been done to meet the requirements of the contract. And once he arrived on the scene, he never invested so as to procure that the work was done. If I could go back to Article 4 of the contract, please, that we were on just now. Thank you. So the provision of a feasibility study is an obligation under Article 2. And then Article 4 provides, after positive evaluation of the submitted feasibility study, NRD will be granted the mining concessions. That's in the English. There is an issue about English and French translations that doesn't matter for this purpose. But what's clear is that not only is there an obligation to provide the feasibility study, if the concessionaire is to be provided with a long-term license, this requires positive evaluation. So in other words, the government needs to be satisfied with the feasibility study before it will grant a long-term license. And just pausing there, one can see immediately that the claimant's case is untenable, that there was a guarantee of a long-term contract, because you can see that that doesn't work on the face of the contract. The purpose of the contract was for the concession holder to prove itself, and unless it did, it wouldn't be granted a long-term contract. So it needed to comply with Article 2, and it also needed to have the feasibility study positively evaluated. Now, so I'm coming to the end of the Zarnak era. That ended in 2008, by which point very little had been done on the concessions at all, and very little invested. And that's explained when you see all of Professor Rupaya's evidence, and he was a geologist at NRD, he explains that very little had been done by the end of 2008. The next period is between 2008 and 2010. And in this period, NRD was substantially owned by HC Stark, which is a mining company. Now, this was the only period in which any material degree of proper investment was done. They did undertake some infrastructure investment, and they also undertook some exploratory work. But even that investment was, in fact, quite limited. It fell very far short of the kind of money envisaged in the Zarnak 39 million investment plan. It seems at most to have been about 13 million, and about a third of the proposed level of investment. And in fact, what one sees in the evidence is that there was a very heavy emphasis and focus by the Starks on one single piece of plant infrastructure, which was a wolframite or tungsten processing plant on the Rutsiro concession. And unfortunately, that turned out to be a white elephant. And I'll come back to why in a moment. And Mr. Ehlers, one of our witnesses, is a mining engineer, and he was the MD of NRD during the Stark era and in the early part of the period after Mr. Marshall took over. And in his witness statement, he explains the state of play in late 2010, when the 4-year period was up and when NRD was applying for a renewed license. And his evidence coincides and chimes very well with Professor Rupayas, who was also there on the scene as the geologist. And there were 5 concessions. Stark had focused their investments in one of them, Rutsiro, and specifically on this processing plant, which was expensive. And it was a plant which did end up being a white elephant, and it never went into production, or it did have some testing. And as a result of NRD's failure to carry out proper exploratory work in advance of building this plant, the plant could never be commercial. And the main problem was that the premise for the build was that it could be used to process rocks which were in the local scree, which were the result of previous colonial mining. The premise being that that scree was itself rich in tungsten, following which at some point there would be delving into the primary ore, which was thought was also sufficiently rich in tungsten. And all those premises turned out to be wrong. And as a result, there was never the ability to produce a commercially viable amount of ore of the right grade to make the plant worth operating. And as a result, the plant never worked at all. When I say never worked at all, I'm not suggesting that at the testing phase it wasn't operable, but it was never commercially viable and never actually processed any ore. So Mr. Cowley said this morning that whether or not it was processing minerals, the plant had to be maintained. That's actually not correct and not borne out by the evidence. The evidence is that not only did it not work because it was not commercially viable, it actually wasn't maintained and couldn't even have been made to work, or at least not without some further rehabilitation. So that's Rutsiro. There's then Nemba, which was a tin mine, and the one that already had the most infrastructure as a result of mining from the colonial era. And the Starks on that concession had made also some limited further investment. But in neither of those 2 concessions was there any significant level of industrialization. And for the other concessions, the other 3 concessions, there was, which are Gikie, Nemba, and Gikie, Mara, and Sabea, there was no industrialization at all. There was just a continuation of artisanal mining. And so that's industrialization, which didn't bear out the obligations under didn't comply with the obligations under Article 2. And it wasn't just the industrialization that was limited. It was also the exploration work and the reserve estimates, which is particularly important when you come to consider the ability to produce a feasibility study. And Professor Rupaya gives evidence about that. And his point is that NRD had only done superficial exploratory work and only approximate estimates of reserves, which, as he says, were more guesswork than anything else because of the superficial level of sampling that had been carried out. And that's dealt with, just for your note, in the witness statement at paragraphs 18 to 21. And because of all that, the only hope in the 2010 application was not to get a long-term contract, but to be given a 5-year license to essentially have another go. The hope being that NRD might do a better job on the concession areas in the next 5 years and they might at that point have a shot at a 30-year license. And that is why, of course, the 2010 application is indeed only aimed at a 5-year license. Both NRD and the government understood that it was an application for a 5-year license, and Mr. Marshall understood that too. We'll be going to some of the evidence on that with him in cross-examination. And there is nothing in the 2010 application to support the suggestion that this was an application for a vast mining license under Article 57 of the mining law. All the document points to this being an application for a 5-year license under Article 45 and a small mines exploitation license. And there's nothing in the document that goes beyond the 5-year window. Mr. Cowley suggests this morning that it's normal in the industry not to go beyond the 5-year window, but no evidence for that proposition either. And it's inconsistent with NRD's own later application, which does indeed produce figures going beyond the 5-year window and out to the 30 years that was sought. And Professor Ripaio was there, and his understanding was that NRD was applying for a small mining license for 5 years under Article 45. Now, part of, as I understood Mr. Cowley's submission this morning, was that any application for a mining license must have been for a long-term vast concession license. That's simply not right, because there's a mining license under Article 45, which is the small mine license, which is indeed what NRD were after. And it's quite clear, we suggest, that Mr. Marshall understood this at the time, and we'll come to that. Now, that's the second block of time. The next block of time is really the period from the end of 2010 to after Mr. Marshall's arrival and Spalena's acquisition of NRD until about the beginning of 2012. And dealing with the acquisition by Spalena, what's important to note is that Mr. Marshall conducted due diligence and spent some time in Mr. Ayler's, and was specifically told about the limitations in the work that had been done in the previous eras, and specifically told about the limitations in the application. He was also specifically told that because of the limited work done, NRD thought that if any further licenses were granted, these would be on a short-term basis. So he went in with his eyes open. He paid a desultory price for the company. And the idea that he thought that there were long-term licenses guaranteed and assured is, in my submission, absurd. Not only absurd at odds with the contract in fact in place, but also at odds with what he was told by NRD at the time, and at odds with the application that had already gone in. Now, that application needed to be assessed and was assessed against Rwanda's 2010 mining policy, and that stressed the need to critically assess and evaluate applications to make sure that in these 4-year periods, effective exploration work was being done and the concessionaires weren't simply conducting artisanal mining on the concessions. And we set out quite a long quote at paragraph 19 of our skeleton. And what the policy is effectively doing is warning against exactly the kind of practices that NRD was guilty of across its extremely large concessions, 3 of which NRD wasn't even pretending to do anything other than purely artisanal mining. Now, while I'm dealing with this shift from artisanal to industrial mining that Rwanda was seeking to push, can I just pick up on one point in paragraph 38 of the claimant's skeleton or pre-hearing brief? If I could, thanks. Thank you. If I could start in the middle of the paragraph, the claimant say, astoundingly, Mr. Gattari in his second witness statement states that Rwandan mining industry remains largely artisanal. Now, there's nothing astounding at all about anything Mr. Gattari says in his second witness statement. And at some point, we could go to it now, but I'll just note it now. Paragraph 20 of Mr. Gattari's second witness statement is entirely clear. What he's saying is the aim and the policy of Rwanda is to industrialize from artisanal mining, and concessions are awarded on that basis. But the process of industrialization is, of course, a gradual one. And the point that he's dealing with in this paragraph is that for so long as the industry has a largely artisanal component, you will see fluctuations in production volumes, because miners and productivity can wax and wane depending on things like the price of minerals and whether mining at an artisanal level is sufficiently economical for the individual miners as compared with other activities. So when you get to a sentence lower down in paragraph 38, the claimants say Mr. Guattari goes a step further and actually dismisses the benefits of industrial mines, such as the one that NRD was fully required to build, because of the substantial sunk costs associated with running such large mines. Now, this is a regrettable part of the paragraph. It simply doesn't characterize what Mr. Guattari says in his witness statement. He doesn't dismiss the benefits of industrial mining at all in paragraph 20 of his supplemental witness statement, and no fair reader of that statement could have thought he was. He, in fact, in that paragraph, explicitly extols the benefit of industrial mining, but he does say that so long as there is still significant levels of artisanal mining, you will have this side effect of fluctuating levels of productivity. And again, I do say it's unfortunate. I've had to spend time, and we've all had to spend time unpicking points like this because they're simply inaccurate. Now, coming back to the acquisition by Spalena of NRD, you'll have seen that there is a dispute about whether there were other components or bits of consideration in the purchase of NRD. Those are points that are said to be relevant to Bayview Group's standing to pursue a claim in this arbitration. We will go to the detail of all that with Mr. Marshall, and we will be suggesting that the claimants have cooked up a story about the alleged liabilities that NRD had to Bayview Group at the time of the acquisition. And we'll come back to this in evidence. The other point to note about this period, so this is the early part of Mr. Marshall's arrival, is that there was and is no evidence to suggest that Spalena had or currently has any financial substance to it. The evidence shows that by the end of 2010, when Mr. Marshall arrived, NRD itself was in deep financial trouble, and that, and we suggest that that's reflected by the purchase price. And Spalena didn't bring anything to the table. It didn't invest, and there's no suggestion that it ever had the resources to do so. So when we get to the 2014 application, and we see that one of the problems with the application, as identified by the Rwandan teams at the time, was NRD's inability to demonstrate that it or its owners had any adequate financial resources. That's a deficiency that was inherent in the purchase. Now, the evidence is that Mr. Marshall and his partner, Muraskovikova, ran NRD as a briefcase company. They borrowed from traders, they ran up debt, they drained the company's working capital. And this meant that the situation worsened under Mr. Marshall's watch: no investment, drop in production levels from the start times, and less ability to control the concessions in terms of illegal mining and environmental damage. Now, the November 2010 application was evaluated by Rwanda in 2011. As with the later license applications, there was an objective evaluation by a senior geologist and staff member, Dr. Michael Biriabarema, who was a witness. Now, in line with what NRD themselves expected when they made the application, he determined that the application, the November 2010 application, was deficient, in particular in respect of the exploration works and the resource evaluation. And just for your references, it's at R111, and we will be going to it in due course. And as we saw in Mr. Imener's witness statement that we looked at earlier, there was no proper feasibility study or resource evaluation as required by Article 2 of the contract. And so what that means is that Article 2 was not complied with, even before you get to the question of whether there could be a positive evaluation of any feasibility study for the purposes of Article 4. And NRD were informed of this in August 2011 by a letter from Mr. Kamanzi. And by that point, as Mr. Mugisha explains, all rights under the contract to a long-term license were at an end. But Mr. Kamanzi did give the claimants, so NRD I should say, an extension of the licenses for 6 months to give NRD an opportunity to prove it was entitled to be granted any further licenses. Now, those license extensions didn't extend the contract, but they did amount to extensions of the licenses. And there was indeed a subsequent license extension, and the last license extension expired in October 2012. And none of these license extensions, and we'll look at the documents, but none of them involved any assurance that any long-term contract would ultimately result or anything remotely of that kind. And just pausing there, it is unfortunate we will be submitting, but the claimants have given so many distorted quotes from these extension letters to give the impression that these extensions were themselves somehow envisaging or encouraging the claimants in the belief of long-term licenses. They simply weren't, and we can look at the documents. There is then, still in this period 2010 to 2012, what we submit as a curious episode which occurs in late 2011. The claimant's case, their version of events, is that NRD agreed a draft long-term contract with an employee of the mining ministry, Mr. Bidega, who's one of their witnesses. The claimants say that Mr. Bidega went so far as to have the contract approved by the minister and submitted to cabinet. This is inaccurate, and we will be exploring that with the witnesses. Mr. Bidega was an employee who was just about to join NRD at this point and did join NRD immediately after the events in question. We dispute that any draft was ever agreed or that Mr. Bidega would ever have been duly authorised to do so. And no such draft was in fact ever put to, let alone approved by the minister, still less ever submitted to cabinet. And that is another factual distortion in the case. One thing I would say about the 2011, this episode and the 2011 draft that Mr. Marshall himself prepared and sent to Mr. Bidega is it is quite clearly a draft contract for a 5-year license. And that's quite an important point, because the claimant's case is that he always understood that there was an assurance of a long-term license, and they even say that the November 2010 application was for a long-term license. It's impossible to reconcile that with what Mr. Marshall was up to in late 2011, which is drawing up a 5-year license. Now, what in fact happened in this period, since we're now at late 2011, was that Dr. Biriabarema told NRD that it should be applying for short-term licenses for only 2 of the concessions. What he was saying is that NRD should be focusing its limited resources on what it thought were the 2 most promising concessions. But after this, NRD insisted at all times in holding out for all 5 concessions, even though it didn't in fact make any renewed application of any kind for any length of license. And indeed, by this stage, NRD had never made any application for a long-term license. So that's the end of 2011. Next period is 2012. In that period, there was the further license extension until October 2012. And after that, no further formal license extensions, though we accept there were ad hoc permissions to remain on site. And just to reiterate, none of the ad hoc permissions either could have been thought to convey any assurance of a long-term license. Just give me one moment to read my own note to myself. I apologise. Yes, it's just to pick up on one point from this morning. Just to clarify our case, contrary to what Mr. Cowley, I think, thought our case was, we do certainly accept that there were formal license extensions up until October 2012, just not beyond. We're not saying there were no license extensions after August 2011. Now, in August 2012, we have, just the timeline, the first incident involving Mr. Benzingi and the RDB, which I talked about earlier. And by the end of that year, the way things stood was like this. First, the licenses had expired in October 2012. Secondly, there had never been an application for long-term licenses. Thirdly, at this point, there were environmental and illegal mining issues in NRD's Western concessions, which had led to NRD being suspended from operating in those concessions. Next block of time is 2013. In January of that year, NRD did put in what purported to be an application for long-term licenses, but it was a desultory document, and we do say it was somewhat telling that in his account of things this morning, Mr. Cowley didn't even mention this document and it didn't feature on his timeline. And the reason for that is that it doesn't fit into his case theory, that the 2010 application was somehow still live and that the 2010 application was in some way for long-term licenses. It wasn't live, Mr. Marshall knew it, and it wasn't for long-term licenses. And that's why he put in this desultory document in January 2013. If you'll note, that's at C054. It was quite literally only a 9-page rehash of points in the earlier November 2010 document, which had previously been seen as inadequate. There's no new material in it at all. And we would suggest that this could not really seriously have been regarded by NRD as a serious and real application. Now, in May of that year, the RDB countered with what was a realistic and serious position, because they indicated that the RDB would be prepared to negotiate for each concession separately, and they wanted to start discussions for a small-scale 5-year license at the Nemba concession, which was the most productive concession by a distance. So that is a sensible position. There was one apparently productive mine, and they said to the NRD, focus your resources on applying for a 5-year license for this productive mine. And that discussion led to one of the letters from Mr. Marshall to Mr. Immoner, of the kind we'll see a lot of in this case, a tirade of complaints and factual distortions. And one of the distortions was that the proposition that NRD was automatically entitled to long-term licenses, which Mr. Marshall had known from the outset was never the case. Now, by this stage, I should say that NRD, this is now summer of 2013, NRD had been allowed back onto its Western concessions following its own promise that it could curb illegal mining on its concessions by recruiting demobilized soldiers. Now, later in that year, so I've just referred to NRD being invited to apply for a Nemba 5-year license. They didn't. And later in that year, it again needed to be the government, specifically Mr. Immoner, pushing the NRD to apply. And he did that in October 2013, making the point to NRD that for a year or so, it had now been operating without a license. The time had come, it needed to apply. And he also reiterated the point that NRD didn't seem to have capacity for 5 concessions and should focus on 2, Nemba and Rutsiro. Again, this advice was ignored. NRD made no new license application. And we would suggest that despite this prompting and chasing, the failure to do so does demonstrate part of the unprofessionalism of NRD's approach. So that's 2013. We then moved to 2014. A new mining law came in the first half of 2014, and NRD needed to apply for a license under the new law. NRD didn't hold an existing license, so it couldn't take advantage of the grandfathering provisions. And also, another technical issue was that the terms of NRD's licenses wouldn't have permitted it to rely on grandfathering provisions anyway. So NRD needed to apply for new licenses anyway, and it had to be prompted by the government to apply. First, it was prompted in April 2014, which NRD ignored, and then it was prompted again in the summer of 2014. And I'll come back to that in a moment, because in between those two prompts, we have the Benzingi issues coming up again, and that starts to happen after May 2014. Because by May 2014, Mr. Benzingi there'd been the arbitration in April 2013, and there had been 2 rounds of appeal after that, with the Supreme Court decision being given in May 2014. And from that point onwards, Mr. Benzingi had the benefit of that award and those judgments. So in August 2014, Mr. Immoner made his follow-up request that NRD make a new application for licenses under the new mining law. And this time he gave them a deadline, 30 days. And it's worth noting that the request from Mr. Immoner specifically identified exactly what needed to be provided with the application. And he asked that the application be made on a concession by concession basis. And it's worth picking up on this again, the claimant's pre-hearing brief, paragraph 22. So they say, despite assurances from Mr. Immoner that negotiations of a long-term licenses would resume, he inexplicably demanded that NRD reapply for its licenses, supposedly as a result of the enactment of the new 2014 mining law, entirely inconsistent with prior communications in which claimants were assured the stalled negotiations towards completion of long-term licenses based upon submitted application and draft long-term license would continue. Never a discussion of the need to reapply because claimants had already applied or in the midst of a process to complete the negotiation of a long-term license. And we would submit this is one of the parts of the skeleton argument, or his pre-hearing brief, that loses all contact with reality and what the documents show. Now, first, it's worth flagging up that a feature we see in this paragraph and also in paragraph 20, just above it, is that a feature of a claimant's case approach, which in both in their claimant's memorials and in Mr. Marshall's witness statement, whenever a document or a meeting refers at all to an extension being given or discussions being had about a license, at each point, the claimants interpolate the expression long-term licenses or long-term contracts to give the impression that the relevant document or discussion was indeed about a long-term license and gave the claimants the expectation that NRD would get a long-term license. Just to give an example of that, you'll see one just above it. If you go up to paragraph 20, one can see when respondent provided another explicit extension of a short-term license in October 2012, respondent stated new contracts have been negotiated as has been communicated to all the existing concession holders, further confirming claimant's expectation that NRD would receive the long-term license. Now, one might get the impression from that there was something in this letter that did foster the impression that NRD would get or would be negotiating long-term contracts. But that document is not referenced. That document is the one at C033, and I'm going to come back to this pre-hearing brief paragraph 22 in a minute, but if FTI could also quickly pull up C033. All that's being said here is from paragraph 1 refers back to extending the previous license. He then says, in view of the ongoing work on reorganizing the mining sector, which will have a bearing on the new contracts that will be negotiated, as has been communicated to all the existing concession holders, I have the pleasure to extend your license. So in other words, all that's being said is there's a new law. All concession holders are being told that the new law will have a bearing on license applications, and he's extending the license. One cannot possibly read anything in this letter as giving any indication or assurance about a long-term contract or a long-term license. And that's just one example, and there are very many in this case. But coming back in the skeleton, in the pre-hearing brief to paragraph 22, which I just read, looking at that first sentence, there was nothing inexplicable that in Mr. Immoner demanding that the claimants reapply under the new law. Mr. Immoner had already been pressing NRD to apply for a license repeatedly and for nearly 1 year by this stage. The application needed to be under the new law because that was what the law required. And the rest of the paragraph is also a fiction. There were no stalled negotiations in respect of long-term licenses. The true position is that NRD had made a hopeless request in this desultory 9-page document for a long-term license in January 2013. NRD had then been redirected in May 2013 towards making a realistic application for a 5-year license starting with NEMBA. Since then, since October 2013, Mr. Immoner had repeatedly asked NRD to make a proper application, suggesting they focus on 2 of the 5. They had been asked again in April 2014 to make an application, hadn't done so, and he was finally in August 2014, giving them a 30-day deadline. Nothing at all surprising, except all that's surprising is the NRD's failure and unprofessionalism in not applying for a license sooner. So we then go to September 2014, where NRD did make an application as required by Mr. Imina, but that application was itself hopelessly deficient. It was another rehash of the 2010 application, and NRD ignored the request to apply on a concession by concession basis. They declined to provide much of the material that had been specifically requested. Recall what I did, Mr. Imina helpfully gave a list of what needed to be provided, and that material wasn't provided. And what they did provide was very far short of what could be expected for a realistic application, even for a short-term license. Now, just pausing there, the claimants repeatedly make the point that NRD didn't have proper access to their Kigali office. There's nothing in this. Now, there are evidential points here where we don't accept the claimant's premise, which we'll be coming to. But leaving all that aside, the critical deficiencies in the application had nothing to do with whether or not certain material could or could not be obtained from the office. The critical deficiencies arose because NRD couldn't possibly ever supply compliant material because its operations and the work done on the concessions was so deficient. To give an example, NRD didn't provide adequate information about the financial substance of NRD and those behind NRD, such as the claimants. They didn't do so because NRD and those behind it didn't have the financial substance. If they had had the financial substance, the material could have been provided. Similar point arises with information relating to, in essence, to feasibility study points, exploration, evaluation of reserves and the like. The reason that we have the 2014 application, it does have accompanying documentation. That doesn't have any new material from the 2010 report. And the reason for that is that there hadn't been any material investment or exploration or resource evaluation in the meantime. So it's got nothing to do with what's available in the Kigali office. The core material that was needed to support a serious application didn't exist and couldn't have existed. And there was also in the application misleading information that was given as to the level of investment from NRD, and we'll come back to that. Now, I've referred at the beginning of my submissions to what happened to this application. I'm not going to repeat it at length. It was evaluated by a team. They recommended it was rejected, and it duly was. NRD was given 2 further opportunities to improve the application and even told exactly what was wrong with it. And by this stage, we're now going to 2015, and the further information provided by NRD was desultory. And on each occasion, with each round of further information, there was an objective review by Rwanda, by a team, and the recommendation to the minister, quite rightly, in each case, was that the application was inadequate and that it should be rejected. And that's duly what happened in May 2015. And throughout this process, Mr. Marshall was still writing bullying letters. They included letters to the president and others making what we suggest are outrageous allegations of corruption and with significant distortions of fact, which are evident on the face of the letters. But one thing that does emerge from these letters is that if the claimants did have a claim of any kind, that claim is on any view out of time, because the claimants had sufficient knowledge before the cutoff date. That knowledge is evident from the correspondence which Mr. Marshall sent. It even includes threats to bring proceedings again under the Bilateral Investment Treaty made as early as January 2012. Now, this is an insuperable difficulty for the claimants. They try to grapple with it at paragraph 30 of their skeleton, where they suggest that the claimants regarded the final letter of 19th of May 2015, which said their applications were refused and they should vacate the concessions. They regarded that as a bump in the road. That's untenable, not only in the face of the facts, but also in the face of Mr. Marshall's own contemporaneous correspondence. Just while we're looking at paragraph 30, if I could ask FTI to pull it up. This is the bump in the road paragraph. They say, this was confirmed by claimants deemed to receipt with respondent after receipt of the May 19th, 2015 letter. For example, Mr. Immoner continued to represent to third parties that NRD owned and operated the mines in its concession. This is also a hopeless submission, which was covered off in the evidence. Mr. Immoner met with these relevant third parties, and you were shown the document this morning at C120. He met with these third parties in 2014, when NRD was still on the concessions. So the fact that the third parties didn't write to Mr. Marshall until 2015 is by the by. And the claimants have repeated this submission this morning as if they hadn't even read the evidence that makes it clear that this is a bad point. Now, as we explain in our skeleton, there was ultimately a retendering of the concessions. The concessions, once they're retendered, didn't go to the military, didn't go to entities connected with the military. That's just another conspiracy theory. So, as I said at the beginning of my opening, once one understands and analyzes the story, one can readily see that there simply isn't anything in this case. There's no expropriation or anything like it. NRD had every opportunity to make well-founded applications for licenses. The government was generous in giving them opportunities, and the government looked fairly and objectively at all the applications that were made. And the applications fell far, far short of making the grade, as Mr. Marshall should always have known they would, because he was told of the problems at the outset when he bought in. And he thereafter did nothing to improve the problems or to conduct further exploration or further industrialization that would have enhanced the position. Now, that's all a whistle-stop tour, and we'll see quite a lot more of the detail with Mr. Marshall. Before I'm going to mention something briefly about the preliminary objection points. Before I do, could I just pick up one other development in the claimant's case, which we do suggest is constantly shifting? And that this relates to the public tender process. There was a normal objective tender process, and the winning tender was duly chosen. The claimants have run an entirely false point that the winning tenderer was Nugali Mining, being a company organized under the Ministry of Defense. That is wrong. That's a point made in the claimant's memorial at paragraph 270. And it's wrong, as we've explained in detail in our memorials and our evidence. Now, there's now in the claimant skeleton a new allegation. There seems to be a variation on this. It's unpleaded, and it's not supported by any evidence, that the concessions were, and it's, I quote, transferred to a Rwandan investor with close ties to the government. That's never been said before. I apologize. I'll give you the reference. I've not got it in my note. Concessions were transferred to a Rwandan investor with close ties to the government. That's never been said before. No particulars have been given, nor any explanation as to how this relates to the public tender process that took place. Now, we do say that unevidenced allegations advanced by way of assertion are unhelpful, and they're inappropriate in any arbitration or litigation. But they're even more inappropriate, we would suggest, when the nature of the allegation is extremely serious. These are public proceedings, as the claimants well know, and they should be taking care not to make serious allegations without proper evidence. But what we've seen here is the opposite of them taking care. Now, I've already mentioned the extravagant claims regarding Rwanda's approach to mineral smuggling and the manufactured claims about an unnamed oligarch. Those are allegations that simply shouldn't have been made. There's no evidence to support them at all. I've also mentioned the extreme claims of corruption and the like against Mr. Immoner made by Mr. Marshall, which are still repeated in the claimant's memorials. And there are two other allegations that I just want to mention now. The first is the reference to Mr. Immoner's criminal prosecution. Now, as the president rightly picked up with Mr. Cowley, Mr. Immoner was acquitted of all charges. Mr. Cowley suggested this morning that the co-conspirators might not have been. We don't even accept that, but in any event, that point is irrelevant. Mr. Immoner was acquitted. Mr. Cowley, on being asked about that, the best he could put it was that he didn't really know, and he wanted to look a bit more at the documents. Well, he shouldn't simply not be advancing allegations, essentially insinuating that Mr. Immoner was guilty of criminal charges when the evidence shows he was acquitted, and Mr. Cowley cannot suggest otherwise. That allegation should be withdrawn, and that should happen at some stage this week, in my submission. Just before I move to the second allegation, I didn't give you a reference to the point I made a little earlier about the tender process. It's paragraph 11 of their post-hearing brief. The other allegation that I'd like to mention now is an allegation in the claimant's evidence, which we suggest is simply untrue, that Mr. Marshall received indirectly via Ms. Murakova a warning from a Rwandan senior policeman that he had angered some dangerous people and his life was in danger. We suggest that is simply untrue, but worse than that, we now see in the claimant skeleton that even this serious allegation has now been distorted to become something even more serious. And if I could just invite you to read what's said at paragraph 11 of the skeleton in the last sentence. And what's said in paragraph 44 in the second sentence. Now, these are extremely serious allegations. They are untrue. They are unsupported by any evidence, because the evidence that is given, and we suggest that that is itself untrue, which is in the witness statements, it doesn't establish or come close to establishing the propositions advanced in paragraphs 11 and paragraph 44. And again, this is the opposite of taking the kind of care that the claimant should be taking with extremely serious allegations of this kind. It's inappropriate, it shouldn't have happened. And what's more, this allegation doesn't even form any proper part of the claim in this case. It's not relied on as a breach of the bilateral investment treaty. And we, on our side, don't consider it appropriate for our side to even be required to spend material amounts of time addressing this allegation that forms outside any proper claim that could be advanced. Now, that's what I wanted to say on the substantive merits points. We've also dealt at length in our memorials with the legal analysis, and we've summarised that at paragraphs 78 to 94 of our skeleton, and we've given references to our counter memorial and to our rejoinder. If I could just pick up on a point from the claimant's skeleton relating to the expropriation claim and how that's advanced. In their skeleton at paragraphs 41, pre-hearing brief, I should say, paragraphs 41 and 45, the claimants explain what seems to us to be for the first time what assets they consider to have been expropriated. And they now seem to say it's a processing plant, roads, bridges, reservoirs, piping networks, testing laboratory and other buildings, vehicle equipment and other tools. But that point advanced for the first time, and there's in fact no evidence either of their property rights to these items or of any taking of these items by Rwanda. So I just want to now move on to say a few words about the preliminary or jurisdictional objections that we have. We've obviously explained these at length in our memorial on preliminary objections and our rejoinder. We do suggest this case fails in limine before one even needs to consider all the merits points I've been spending time on. And as the tribunal knows, our objections are of 5 kinds. First is temporal, and there are 2 aspects to that, which we explain at paragraphs 51 and 59 of our skeleton, giving the references to our rejoinder and our memorial on preliminary objections. And the first aspect is that some of the claimant's claims on analysis amount to a complaint about matters that took place before the treaty even came into force, and the treaty doesn't operate retroactively. Secondly, the claim, and this is more of a point for this week, the claims are out of time because they were submitted to arbitration more than 3 years after the date on which the claimants acquired knowledge or should have acquired knowledge of the breaches alleged. And for that purpose, the relevant date to have in mind, we suggest, is 12th of June 2015, which is when this claim was submitted. The claimants are wrong in their suggestion that 14th of May 2015 is the cutoff date, because that's the date of the submission of a different claim to arbitration, including a different party, and that claim was not accepted by ICSID. And we would suggest that the claims are clearly out of time in any event on either cutoff date. And this is an aspect that we would invite you to particularly keep in mind when you listen to all the evidence, because all these alleged breaches, all the relevant conduct and matters complained of, all took place long before the cutoff date. The claimants knew all about them because NRD was in fact, or Mr. Marshall, was in fact complaining vociferously at the time. We say his complaints were tendentious and without merit, but it's impossible for the claimants to suggest they weren't fully aware of the matters complained of. And they were even complaining at the time that there was a breach of treaty obligations and expropriation by the government. The second area of preliminary objection relates to standing, and in terms of this week's focus, I'd particularly pick up on the BVG points, because we say BVG simply have no standing because it has no interest in NRD or in Spalena. And we will be spending a little time with Mr. Marshall on the claimant's allegations that BVG somehow did acquire a sufficient interest in NRD as a result of money allegedly lent to NRD under this cooperation agreement, or out of alleged claims that BVG had against NRD under that agreement, or out of alleged transfers of assets to NRD. Even leaving aside all the legal problems that arise with the way the claimant's case is put, we suggest that the facts and the evidence relied on for all those points involve a high degree of invention on the claimant's part, which we'll be exploring. The third area of objection relates to the lack of jurisdiction ratione materiae, which we address at paragraphs 67 to 72 of our skeleton. And for this week, we'll be particularly inviting the tribunal to pay particular regard to the evidence showing the complete lack of any relevant investment or substantial contribution to Rwanda's economic development by the claimants. Spalena acquired NRD for you will see at times the claimant seeking to give the false impression that the investment purportedly made by the Starks prior to the arrival of the claimants was in some way the claimant's own investment. You'll see an example of this, just to pick up the skeleton again, the pre-hearing brief again in paragraph 35. See in the middle of this paragraph, contemporaneous documents demonstrate that claimants invested at least 13 million euros by the end of 2010. Now, by the end of 2010, of course, the claimants hadn't. They only acquired NRD for at the end of 2010. That 13 million figure is not a reference to any investment by the claimants. That is the figure that I said was the Stark and Zarnak, although in practice almost all Stark, investment in the prior period, which, as I said, was a third of the amount foreshadowed. And we say that NRD's and the claimant's accounts of the investments that were made by NRD are highly unreliable, and we'll be exploring that in the evidence. And when it comes to the claimants themselves, leaving aside the Starks, we don't accept that there were any material investments after their acquisition. And indeed, that was one of the reasons why their 2014 application was so hopeless. And I would just invite the tribunal to note that the lack of any investment by a tribunal now in fact appears to be largely accepted, at least impliedly. And one sees that from paragraph 9 of this document. If the FTI could go back to paragraph 9. Thank you. There's a reference to various work done, which is, I should just point out, in fact, new assertion, not supported by evidence. So there's a lot of new assertion here. But then the punchline is most of this investment came from retained earnings, and claimant's intention was to invest more heavily in the concessions after the receipt of the long-term licenses, which was necessary in order to extract substantial investment. So there's an implied concession here, an implied acceptance that the claimants didn't actually put any new money in, despite what we'll see are untrue assertions to the contrary given by Mr. Marshall at the time. Now, the fourth area of objection relates to the lack of any prior notification or request for settlement by Spalena as required by Articles 23 and 24 of the treaty. And we say that, put shortly, the claim by Spalena is the one pursued in this arbitration, and there was no compliance at all with the articles in respect to that claim. The claimant's argument in their skeleton is that the claims are functionally identical to claims that were notified, and that's obviously wrong. One only needs to look at the various points that we make in our memorials, both on the merits and in relation to jurisdiction points, to see that the centrality of Spalena as the entity bringing the claims, and the idea that notification of a claim not brought by Spalena constitutes notification of a claim by Spalena is, we submit, hopeless. So about to move on to the evidential stage, and Mr. Marshall, I know, is going to start. Just one point on the evidence. We've noticed on our side quite a lot of factual assertions in the claimant skeleton that are new and unsupported by evidence. Now, I know the parties have an opportunity to supplement their evidence with evidence in chief, but we hope that this doesn't foreshadow that the claimants are going to seek to use evidence in chief to advance extensive new evidence that's never been notified to us. And we submit that would not be an appropriate use of their time. I would also add that we would ask Mr. Cowley or Mr. Harrison, whoever's doing the evidence in chief, to please avoid putting leading questions to elicit evidence in chief. It goes without saying that the same applies to redirect, and if there are any leading questions, we will, I just put down a marker, be inviting the tribunal to discount any evidence that's elicited in that way. So unless I can help further, that's what I wanted to say by way of opening.
Thank you very much. As I read the timetable, you're half an hour ahead of your allocation.
Well, I've got a lot to get through with Mr. Marshall, so I'm delighted.
Very well. I don't know whether Mr. Marshall is immediately available.
But I should say, I'd be happy if everyone wants to stop for 10 minutes to sort of organise.
Should we have a 10-minute break? A 10-minute break? I think that would be very welcome. Thank you very much.
All right, Mr. President, we will go ahead and open up the breakout rooms and get the witness ready to go.
Please bring you in now.
Okay, we'll do.
Mr. President, while he's coming in, can I just say, I'm afraid we still haven't had the AILA's email. As I understood from the application, it was one email with one attached document. And I really struggle now to see why we haven't got it.
Mr. Cowley?
In the next 5 minutes.
Apologies. My understanding is Mr. Harrison is sending it now. When we were talking before, Mr. Harrison, like I said, is here with me. Just by way of brief explanation, the way our system works, we can't be on a Zoom call. We can't be on anything that requires out of office connection, like working from home, working in a conference room, and be on Zoom. It will not hold. So to be on here and present with his, attending, and to be on the network are two different things. So while we're going, once we started up again, the email he hadn't hit send yet. He had to stop and go back off, back onto the system. It's my apologies, but we are in our office, but we have to maintain a separateness in order to maintain connection with Zoom. I did not understand that when I said it was being sent now, that it hadn't been completed yet. It wasn't completed during the questioning. It's being completed now. Mr. Harrison will stay off line and stay off the Zoom until it goes out.
Very well. Right, well, let's continue then with Mr. Marshall.
Mr. Marshall, I'd like to ask you to introduce yourself to the tribunal. In addition to introducing yourself by name, can you provide for the tribunal a brief explanation of the background of your professional career?
Yes, Mr. Marshall, first of all, has to make a declaration.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you.
I'll restate,
Carry on with
Mr.
the
Marshall.
direct.
Thank you, Your Honor. Mr. Marshall, please introduce yourself to the tribunal, and in addition to introducing yourself by name, please give a brief explanation of the background of your professional career.
My name is Roderick Marshall. I, as a young lawyer, moved to Slovakia and the Czech Republic when socialism collapsed. I was with a larger firm at that time. We started advising. In fact, I was the only resident lawyer in Slovakia at that time. There were many foreign lawyers in Prague, but only me in Slovakia. Their biggest problem, they did not have experience, anything to do with the markets, sort of common sense things that you and I might automatically take for granted. Their desperate need was for liquidity. They started a series of financing the Slovak Republic, even more so when they split from the Czech Republic, beginning of end of 2012, I guess. So I was, with only limited background in sovereign debt financing, began working with a very senior partner from my then law firm, which was Squire, Sanders and Dempsey. And we provided that service for the Slovak government. There were some conflicts between the Slovak government and our law firm, and we split off, and we continued performing sovereign debt financing for the Slovak government. We kept it very simple. In a certain way, blind luck for both us and the Slovak Republic. We set the terms of the loan arrangements. We did not allow significant variations. So Slovakia paid in full and on time, and was always able to refinance in successive transactions because it had a good reputation. I should add that Slovakia was unique in Central Europe at that time, being the only country which...
Mr. Marshall, you've only got 10 minutes, so I suggest you don't spend too long in Slovakia.
Oh, anyway, yes, thank you for that. 2003, the market in Slovakia was changing. I was approached by USAID because we're a very small firm and could provide this sovereign debt financing services cheaply to offer to provide it to Rwanda. So at the urgings, as I say, of the State Department and USAID, I met with first a group of Rwandans in a delegation in Boston. They asked me to come and visit. I visited. We began providing them with pro bono ad hoc assistance on sovereign debt issues. And at that same time,
I'm going to ask you to stop only because I'm trying to get to just the highlights.
Yep.
At this point. How long did a relationship with Rwanda regarding such services, your professional services as a lawyer, transactional attorney specifically, how long did that continue?
The whole time. It began, it was very ad hoc at first because, they were just coming off the Congo War. There was really a lot of chaos. People were in positions where they didn't have good experience. Everybody needed help of one kind or another. and they wanted to be able to, they were particularly appreciative of what we were offering because, we had done it in Europe, we knew what we were doing, and they were able to be sure without having to pay very much, in this case, nothing at first, to get the same services we provided to European countries, sovereigns. So it was very ad hoc for the central bank, questions from time to time, sort of ongoing dialogue. Very quickly, they asked us, look, we also very badly need US investment in Rwanda. And the reason being that they were the highest per capita recipient of US foreign aid, not including military aid. So, and there were no investments from the United States, zero. And so they said, can you put together a group? Long story short, we did put together a group. We went back and forth. They created most of the documents for us in the preparation for requests for a license, for a long-term mining license. They were issuing then, by statute and Rwanda law, there are defined provisions for how mining concessions are held and operated. And that's what was being issued at that time, not more generic licenses. So that's what we did.
And Mr. Marshall, how long did you provide services, legal services and related professional services to entities within Rwanda? Until what period of time?
Well, it was very much ad hoc until really 2010, because there was so much organization. These were greenfields. There was nothing there. So for Bisesero. So we were spending enormous 24 hours a day of our time working on sorting those things out. We would get occasional requests for something. People would come and see us, even though we were in a remote area, say, what about this? How do we do this? And we were traveling back and forth to Kigali, so we also had communications there. It really became a significant portion of our time beginning in 2011, as we were taking responsibility for NRD and were more frequently in Kigali. And then even more so when, it's odd to say, but when we didn't have tags and couldn't sell materials, our business was frozen. So the military then came and bombarded us with requests for memos and assistance in meeting companies in Slovakia. We had delegations going back and forth. That was key element for them of gaining access to European Union technology through the European Union process. But that really began in 2000 in earnest, although it was ongoing, but in earnest, 2014, 2015, and into 2016.
Thank you. Nothing further on
Thank you.
direct.
Yes, Mr. Hill.
Mr. Marshall, you explain in your first witness statement that you are the president of the Spalena company and the president of Bayview Group, yes?
Yes.
And you've had those roles since the formation of those companies, correct?
Certainly with regard to Bayview, I had previously used the Spalena company as an entity to run a redevelopment project, reconstruction of a building in Prague. That's what the name Spalena is. It was a joint venture with the Archdiocese, and whether I was always the president, I can't say for sure. But that company went inactive when the project was over.
And you are responsible for giving instructions on behalf of the claimants, both claimant companies, to the claimants' lawyers in this arbitration, Dwayne Morris, yes? You've given the instructions.
Primarily.
And you presumably read and approved the claimants' various memorials in this arbitration before they were served.
Yes, I believe I did.
So that would be the claimant's memorial, the reply memorial, and their counter memorial on preliminary objections, yes?
As far as I recall, yes.
And in each case, you were satisfied that the factual version of events that was set out was the version of events that you wanted to give to the tribunal in this arbitration, yes?
Yeah, if you're implying somehow that there was an error, I'm not aware of it.
Now, the Spalena, I apologize if my pronunciation isn't right, but I've called it Spalena. Spalena company, Spalena company was a company incorporated in 1998, yes?
Yes,
Bayview incorporated in 2007.
yes.
Yes. Your memorial, sorry, I didn't mean to cut
That's my recollection, yeah.
Your memorial suggests, claimant's memorial suggests at paragraph 7 that Spalena is an investment vehicle of the Bayview Group. But Spalena was in fact formed before Bayview and isn't any kind of subsidiary of that group, is it?
Well, I have to unpack what you just said.
Well, why don't you unpack what your memorial says? Do you want to look at it? I'm sure it can be brought up on the screen, paragraph 7.
Yeah, but you're using a defined term by saying it was an investment vehicle sorry, Spalena was investment vehicle of Bayview Group, right? So I don't know when it was. I can give you an explanation of the dates, the approximate dates of what occurred when, if that's what you're, without being able to.
Just trying to understand, making sure I've got your evidence on the relationship between Spalena and Bayview Group.
Can you make them bigger?
Now, I may have given you a wrong reference, Mr. Marshall. Can you just tell us what you say the relationship is between Spalena and Bayview, bearing in mind that Spalena was incorporated before Bayview?
Yes, yeah. No, it was a question of the circumstances forced on us by Rwanda that we followed through this pattern of changes. Bayview Group was the holder of Becesero, okay?
Yeah, carry on, yes.
Yeah. Bayview Group was the holder of the Becesero license. It was registered in Rwanda, not as a Rwandan corporation, but as a Delaware corporation licensed to do business in Rwanda.
Well, just going back to paragraph, if FTI could look at paragraph 6. Spalena is an investment vehicle of the Bayview Group. Now, what do you say? That suggests that Spalena is in some way under the control and owned by the Bayview Group. What do you say is the shareholding relationship between Spalena and Bayview?
No, they're two Delaware companies, okay? When I don't, I need to explain to you the background because otherwise, you're presuming an answer that isn't necessarily correct. Spalena is an investment vehicle of Bayview Group in the sense that Bayview's money and assets were contributed to Spalena. That we had no choice. That was forced on us by the Rwanda government.
Who owns Spalena? Who owns Bayview?
It's a group of US investors that are the same in both cases.
You're saying the same investors own both?
Yes.
We'll come back to that.
I don't know that that's always been the case, but yes.
Can we just look at paragraph 15 of your first witness statement? This is in a section. If you just go, if FTI could just go back a page to see where the section starts. Got a section entitled BVG became a concession holder and subsequently invested in NRD.
Yes, through Spalena.
Now, you then get to paragraph 15 of this witness statement. So you're dealing with the question of BVG investing in NRD. And you say at the end of 2010, BVG's investors invested in Spalena so that Spalena had capital to acquire the shares of the parents of NRD. BVG's investors did so in order to continue investing in Rwanda's mining industry. In this way, BVG invested in Spalena, which invested in NRD, which serves as a local Rwandan investment vehicle. BVG and Spalena are commonly owned affiliates. BVG and Spalena then capitalized and funded NRD's liabilities and expenses in order to develop and operate the mining concession. Do you see that?
Yes.
Now, you were not suggesting in your first witness statement that BVG had any shareholding in Spalena, were you?
I don't know what you mean in my first witness statement.
This is, in this paragraph, you are not suggesting that BVG had any holding in Spalena. The point you're making there is a point that, in fact, I think you just made orally, is that you have common investors. Investors of BVG also own Spalena.
Yeah, I'm not following you. It says BVG's investors invested in Spalena.
Yeah.
You're saying that was not that, or what do you mean?
No, I'm not at this stage taking issue with your proposition that the same investors own BVG and own Spalena. I'm trying to establish whether you are saying that BVG has a stake in Spalena, and you are not saying that in this paragraph, are you?
I am saying that in this paragraph.
Well, where?
BVG investors invested in Spalena.
Yes, but BVG didn't. They have, that's your point, they have common investors, but BVG, on your evidence, has no interest in Spalena.
I'm sorry, I shouldn't. Yeah, I think you're misinterpreting the meaning of that.
Well, I'm making what looks
in
like...
this way, the second sentence says, third sentence, in this way, BVG invested in Spalena, which invested in NRD.
But in this way results from saying BVG's investors invested in Spalena. There's no evidence from you about BVG taking any stake in Spalena, is there?
They had to. We were forced to. We had no choice.
And if you had considered that BVG had itself any direct interest in Spalena, you would have explained that in this witness statement, wouldn't you?
No, I think you're misrepresenting it.
Well, I'm just reading your statement. It's in a section.
In this way, BVG invested in Spalena. I don't think, I mean, that's pretty clear, right?
Well, it's clear, but in this way, and this way is BVG's investors investing in Spalena. That's what the first line says.
Oh, I don't read it that way.
Well, tell me how you read BVG's investors invested in Spalena.
Well, I would have, obviously the intention, maybe not to you now, but it was always understood in Rwanda that BVG's assets all got contributed to Spalena because BVG could no longer function because they were denied the possibility of continuing to be a foreign investor operating in Rwanda. So when we lost that possibility, we had to transfer the assets of BVG. BVG had to transfer the assets to Spalena.
No.
And in exchange for that, they became an investor in Spalena. If you think that's inartfully worded, I'm sorry for it, but that's not what I'm not understanding it the way you read it, the way you say you read it.
What has in fact happened is that had you considered, I'll start that question again. Had you considered that BVG did have a direct interest in Spalena, you would have mentioned that in this witness statement, wouldn't you?
I'm sorry, ask me again.
Well, Mr. Marshall, you're a lawyer dealing in commercial transactions and an intelligent man, you know precisely what I mean when I refer to direct shareholdings. Had you thought that BVG had an interest in Spalena, you would have mentioned that in this witness statement, wouldn't you?
That's what it said. BVG invested in Spalena.
Now, you recall, don't you, that in May 2019, the respondent in this arbitration filed a memorial on preliminary objections in which it identified a number of preliminary objections to the claimant's case. And one of the preliminary objections was that BVG was not an investor in NRD and did not have standing. Do you recall that?
No.
You don't recall that?
No.
Well, in August 2019, the claimants filed a memorial in response, and that was accompanied by your supplemental witness statement dated 16th of August 2019. And if we could go to that statement, you have a section headed BVG's investment in NRD and control of BVG. Do you have that? If it starts at paragraph 3. Yeah, I'm just taking you to your own. So this is your supplemental witness statement of 16th of August.
Thank you. I have 2 here.
It's the first one, not the second supplemental. That's it.
Thank you.
Starting at paragraph 13. Sorry, starting at paragraph. We'll start with page 2. Thank you. So you've got a section headed BVG's investment in NRD and control of BVG. And you make 2 points in this section. Actually, FGI, don't blow it up if you would let someone else asks. Can you not blow it up? Because I think it's easy to read.
No, it's not. I can't.
Oh, sorry, can you? Well,
No.
I'm going to ask you to look at 2 pages. Do you have a small screen, which means you can't read it?
I don't know. It's micro print right now. When
Is
you
it?
close it
Right.
up, I can read it.
Well, I'm going to ask, in that case, perhaps blow up paragraph 4 and 5, if FTI can do that.
Simultaneously, it'll still be a little bit small if they're both on screen at the same time.
Well, at paragraph 4 and paragraph 5, you deal with a claim that you say BVG had against NRD. Okay, that's 4. Can you, perhaps FTI can blow up 5? It's your witness statement, so I hope you're reasonably familiar with it. And then, so you say those paragraphs, that there's this claim that BVG had against NRD. And then if FTI could go to paragraph 6. You say there that the claim was written off and assigned to Spalena. And then you say, so that's the first point you make. You've got this idea of a claim that was written off. And then you say at paragraph 7, that BVG had assets totaling 2.25 million, which it transferred in exchange for an ownership stake. So that's what you're saying in your supplemental witness statement. And both of those points were relied on in the claimant's memorial in response to preliminary objections. Now, my question, I'm just reminding you of your witness statement. My question to you is that neither of these points featured at all in your first witness statement that you filed in support of the claim in this arbitration, did they?
I don't know.
Well,
You have
you've
to
looked
show
at your
me
first
that.
witness statement. You looked at your first witness statement where you dealt with the topic of BVG investing in NRD, and neither of the points that you make in your supplemental witness statement feature at all in your first witness statement, do they?
I'm sorry, you're going to have to show me back where you're
Yeah,
referring
please,
to.
no, do. Why don't you look at, you could be shown again First witness statement, paragraphs 13, 14, and 15. Do you have a hard copy witness statement with you or not? Or you
No.
of your own witness statements? No.
No.
Okay. Paragraphs 14 and 15. There, just leave it like that if Mr. Marshall can say if he can't read it.
No.
I wonder if over the course of the next day or two, is Mr. Marshall, are you in the Dwayne Morris offices or not?
Yes.
I wonder if he could be given a bigger screen, because it's enormous on my screen. And we got a lot of documents to get through, and I do need to be able to put up a page. Are you on a small laptop screen or something?
I think this is FTI. These are not Dwayne Morris's screens.
But is it a small laptop screen that you're on?
Yeah, but sideways.
Well, if FTI could in turn blow up paragraphs 14 and 15. Thank you. So nowhere do you make either of the 2 points that you see in your supplemental witness statement, do you?
You mean I don't talk here about what those assets were? It says BVG investors did so to continue investing in Rwanda's mining interest, but it doesn't list them here. Is that what you mean?
Doesn't really say anything, does it? You have made points in your supplemental witness statement that simply aren't there in your.
Well, your character, I mean, as I understand it, you're saying that that means that it didn't happen. But this language to me was what it was intended to say, was that investment was made.
Now, let's go back to paragraph 4 and 5 of your supplemental witness statement. I'm going to suggest to you that you have come up with the versions of events in this statement in order to meet the claimant's objections, their preliminary objections. Do you want to comment on that now, or should we do so afterwards? You've come up with a version of events that BVG has this stake in Spalena, haven't you?
I'm sorry, I've lost the thread here.
You've come up with this version of events that BVG has a stake in Spalena, haven't you?
I understood that you said that, but where am I looking at? Or where
I'm
am I
asking you. I'm just asking you.
Did I, in order? No. The events on the ground drove what happened to us and why we had to contribute BVG's assets to Spalena.
Well, let's start with paragraph 4.
We had no choice.
So let's start with paragraph 4 and 5. So you say that there was this cooperation agreement between NRD and BVG on the 1st of November 2010. That's your evidence, yes?
I think that's the evidence in the trial, yeah.
And then you say it involved NRD working on the Bisesero concession, yes?
Jointly, yes.
And you say, yes?
NRD borrowed, yes.
And you say that in the period prior to the acquisition agreement from the start, so this is a 7-week period. Is that what you say?
Yeah, but you're mischaracterizing it by phrasing it that way, I think. What had happened was we started this cooperation agreement really in, I would say, mid-September. And it carried on. It was not documented until November 1st by Ehlers with whoever he, on his NRD board, had to get permission from. Whether it was a tacit permission before, I don't know on what basis they were operating if they didn't have it authorized before. But it was memorialized on in the November 1st agreement.
Now, this cooperation agreement didn't feature at all in the claimant's memorial or in your first witness statement, did it? You accept that?
It didn't feature where?
At all, in your claimant's memorial or your first witness statement?
I would have to go through it to see.
And are you able to explain why?
And I didn't even know it wasn't there, so I can't explain why.
And your current case in this arbitration is that amounted to an investment in NRD. But we saw your witness statement, your first witness statement had a whole section on BVG's investment in NRD, and there's no mention at all of. Is there?
I would be surprised if it isn't there.
Be surprised if it
Is not there.
well, it's not there.
Okay.
And the reason it's not there is because there was no.
That's simply not true.
Your current case also suggests that there is an alleged. Again, if those liabilities had truly existed, they would have been mentioned too in your first witness statement, wouldn't they?
No, they wouldn't necessarily.
Well, coming back to C122, if we could look at this cooperation agreement document. FTI could bring that up. We can see from the third line of this document that on the face of this agreement, this is NRD and BVG agreeing to cooperate in the management of the Bisacero concession. That's right, isn't it?
Yes.
And then paragraphs 2 to 4 deal with what on the face of this document NRD is to do. It's to buy necessary artisan mining support equipment for BVG, and then using money provided by BVG, and then also loan its own equipment to the artisans. And they're to buy enough artisan support equipment so the artisans in the concession can generate the maximum possible minerals. And there's references. NRD's got to keep proper financial accounts of the transactions made on behalf of BVG. And then NRD's got to loan its bulldozer and tipper, wheel loader and tipper trucks. And then the NRD equipment should be provided for such period determined by BVG. And they've got to loan enough machinery and equipment for minerals to be processed on site. And then NRD should create a program of cooperative artisanal miners. So on the face of this document, BVG was asking NRD to conduct the mining operations for BVG at the Bisacero concession, yes?
No.
Did you say no?
No.
Well, that's what you explain what your understanding is.
The way it was operating, this is Anthony Eller's draft that he wanted approved for his board, or I don't know what authorization process he had at NRD internally. What we were doing we were running the two concessions jointly. NRD had substantially more equipment. They had the plant, which was nearing completion at that time. They had a lot of staff, a lot of mining and minerals expertise, which was a great boon for us since we could cooperate. They needed some of our equipment for operating the plant. They needed our staff who had different kinds of relationships with different people. And so it was a real cooperation. This is Anthony Eller's attempt to memorialize it for his board. For us,
take it in stages. What clearly is involved is that NRD is going to be managing the Bisacero concession, isn't it?
It was cooperation in running them. It's not like we left and he came in and ran it. That's a complete misunderstanding.
And it did involve purchasing equipment with a loan from BVG, yes?
Yes.
And it involved lending BVG NRD's bulldozer and wheel loader and tipper trucks, yes?
Yes.
And that's presumably because BVG needed to borrow those from NRD because it didn't have its own, yes?
No.
Well, it's you can see a whole scheme in paragraph 2 of NRD having to provide
I agree that's what it says, but that the function was not because we didn't have it. We had different kinds of specialty equipment, which is why he needed our specialty equipment as well. There was a
And you can-
benefit to him at the same time.
And you can see at paragraph 3 that at the end that NRD is to loan enough machinery and equipment for minerals to be processed on site. So in other words, BVG is dependent on the loan from NRD of sufficient equipment to enable minerals to be processed.
Yeah, but that, again, you know, the way these concessions are large areas and there are different deposits at different places. And Bugugu had what they had identified was a very promising deposit. And instead of shifting equipment from somewhere else on our concession, we agreed that it would be better to bring in new equipment just for Bugugu.
Now, NRD is under this agreement represented by Mr. Ehlers, who's the managing director on the face of this agreement, yes?
Yes.
And that signature at the bottom of the page, which is purportedly Mr. Ehlers, as I understand you now accept, is not his, yes?
We never said that it was his. It was authorized by him to sign it.
When you put this document,
there are other counterpart signed versions.
when you put this document in this arbitration, you didn't say, but this was not in fact Mr. Ehlers' signature, did you?
I'm sorry, that would never even occur to me. If you put somebody's name / somebody else's initials, that suggests, I think, universally that that's not his signature, but is authorized by him to sign.
So just explain that again. You consider that this is not representing to the reader that this is Mr. Ehlers' signature?
No, it is representing to the reader that Mr. Ehlers authorized it and had somebody else sign it because he wasn't there or whatever the circumstances were on that day.
Now, you're a lawyer by profession, Mr. Marshall. You don't really think, do you, that this was telling the reader that this is not Mr. Ehlers' signature, but that it's something else?
100%. If you put somebody's name / somebody else's initials, that means somebody else signed it on their behalf.
I suggest you don't really think that, do you?
I suggest you're sorely mistaken. Maybe it's a British practice, which is not the same in the United States. I don't know any lawyer who wouldn't assume that there's something that they need to look at with regard to that signature. A signature is a signature. If you put a / and you put somebody else's initials, that means that the signature was presumably signed by somebody else. And I've never understood the convention otherwise.
Paragraph 2 of this document refers to you have suggested in your witness statement that this was in fact advanced, and that's not true, is it?
Yes, it was advanced.
How was it advanced and by what means?
I don't recall, but I'm sure it was advanced.
You were aware that the respondent disputes this, and you haven't produced a single piece of evidence to suggest that this was advanced, have you?
I don't know whether there's another exhibit which shows that it's been advanced or not, but I'm certain that it was advanced because I was involved in it. In fact, it was somewhat delayed, and Mr. Ehlers and I got into a short spat about it had been a week late and he had been embarrassed.
Mr. Marshall, you're making this up, aren't you? You're making this up, aren't you? You want to answer that? You're making this up.
I find that really condescending.
But it's a question, are you denying it?
I find it condescending and I'm denying it.
And if it had been advanced, you would have been able to produce a bank statement from BVG or some evidence of some kind to support this statement, wouldn't you?
You know, what you've taken from our offices, and this is the period, and still when all of these documents would have been in our offices and your client took them. So if we can get all those documents back, I guarantee you we'll be able to show them to you. Come
on, Mr. Marshall, you're not suggesting that whatever happened in the office in Kigali in 2014 would have prevented you from BVG, which is a Delaware company, from going to its bankers to establish proof of this?
It would not have been, it was in, no, I'm sorry. I think you're missing the essential aspects of how these transactions work. The money would have been, and I don't know which bank account because we had several because of troubles and various issues going on. The money would have been in Rwanda. The money would have been transferred to Ellers. He may have insisted on it in cash. Very rarely did you do bank-to-bank transfers.
So you're suggesting there was
because of the argument that I had with Anthony Ellers and had to apologize because it was some handful of days late.
You're not suggesting there's. Where are you?
No, it was paid in installments over the time as they needed. We would not have given him money, would I?
And you would have had no difficulty in getting evidence of this from BVG's bankers to validate this, would you? If it had been true.
No, you're again insinuating facts that are not completely untrue.
Now you see that NRD was obliged under paragraph 2 to keep proper financial accounts of these transactions. Mr. Sindayagaya was the senior accountant of NRD at the time. He was not aware of any of these liabilities.
You'll have to take that up with Mr. Singaya.
Mr. Cowley can take it out of Mr. Sindayagaya, but what it demonstrates, doesn't it, is that these liabilities didn't exist, because if they did, NRD's senior accountant would obviously have been aware of them, wouldn't he?
Well, I think it's interesting that he calls himself a senior accountant. He was a bookkeeper, and he should have been aware of it. My expectation was that he, in fact, would have handled it. For him to deny it is extraordinary and false.
Now, you say at paragraph 5 of your witness statement that that is also something where you haven't identified a single document to establish the existence of this claim, correct?
Well, I think we may have included it in the police report. That may have been still available from our office, if not from the office from the police.
If this had been true, Mr. Marshall, you'd have been able to produce emails between you and NRD or the controllers of NRD saying, look, there's not a single document has been produced by you to establish this assertion.
Well, I don't know whether that's true or not. I know the facts were what the facts were. We had an inventory, whether it was Mr. Ellers or somebody else. We believed it was Mr. Ellers. Mr. Ellers committed several embezzlements, and that was part of the reason that we fired him, including human trafficking and other things. So we were very, very upset. Would we have been focused on given all of the other crimes that he was committing at that time? I'm not sure. I'm not sure.
Talking now about what you said.
That was the inventory of our minerals in Bisesero, which we had not sold any.
Mr. Sindayagaya has heard nothing at all about this alleged claim. And again, he was a senior accountant.
No, he was not a senior accountant. He was a bookkeeper, and he embezzled money, so we fired him.
And he also says in his second witness statement that it's impossible for that kind of. That's correct, isn't it?
He's mistaken.
Well, which bit is he mistaken about?
We began operations in Bisesero in 2007. We had, in retrospect, I would not have stored them and kept them. To me, it was like money in the bank, but I believe them to be secure. they disappeared. Whether it was Mr. Ellers or Amy Singaya himself, I don't know who stole it. But we did not get the financial benefit from those minerals.
Can we look at the sale and purchase agreement between you and Stark? And this is at bundle C068 at page 9.
Steve, this is subject to the non-disclosure agreement. I don't know if there's some process you have to alert somebody that this is subject to a non-disclosure.
Let's look at page 9, little f.
May I ask the tribunals that I could just reassure Mr. Marshall that there's been a discussion about the process as to how to select out from public viewing those materials that are considered confidential by the parties before they become fully public.
So looking at little f, you'll see that
No, I don't believe so. I think this refers to only.
it's saying the target. So sorry, that is on page 12. Again, can you go to little n? You can carry on. If you go to the last page of a document, this is the. Now, you're not answering my question. I'm going to ask you to focus on my question. Now, you said this is a misrepresentation. Now, this is a sale by Stark. It's a professional mining company. Let's move on to the other interest that you say BVG acquired in Spalena, and that is an interest you say that arises by virtue of an alleged asset transfer from BVG. So you know what I'm talking about?
No.
Well, you say it's your case is that BVG acquired an interest in Spalena because there are assets from BVG, various bits of plant and equipment that were transferred from BVG to NRD, giving rise to an interest in Spalena. Yes, you know that part of the case I'm talking about.
Yes.
Now, can we go to bundle C-123? This is a resolution from 7th of March 2012.
27th of March.
Yes, sorry. 27th of March 2012. And so before this document, on any view, Bayview had no interest in Spalena. Is that right?
We're the same people. How do you mean? Bayview Group as an entity? What was the liabilities of Bayview Group versus Spalena? Spalena was, at the time of the purchase, was simply a shell. We wanted Bayview Group to buy NRD, the parent of NRD. That would have been the Stark transaction. Stark was aware that Dr. Michael had, for reasons we don't know, prohibited Bayview Group. There was, in 2011, there was an amendment to the corporate laws of Rwanda. All companies had to re-register. And BVG, as a foreign company licensed to do business in Rwanda, was not given that opportunity. And we think it was part of his effort to push us. So we suddenly, with the agreed upon gentleman's agreement, BVG could no longer operate in Rwanda. We were
going to come
prohibited.
back. Don't worry, you'll get a chance to talk about that bit of a story later because I'm going to come back to that. Let's just focus on this resolution. So this is a resolution from you as president and sole director of Bayview Group LLC, and we also have the equivalent document for Spalena at C124, if that can be brought up.
Yes, right.
Now, were you aware, and I'm sure you are because you read the memorials, that the respondent doesn't accept the authenticity of these two documents?
I'm aware that they don't accept the authenticity of almost everything we submitted.
Now, the respondent made its position clear in its rejoinder. If these had been genuine documents, there would inevitably have been some contemporaneous documents, emails, drafts, to demonstrate their existence in March 2012, wouldn't there?
We had lost Becesro. The police had come and taken it. What else? Sorry?
You know how you operate your emails. You have your own email account. There would have been if these documents had existed in 2012, you would have had no difficulty producing emails which demonstrated their existence, would you?
To who? This is an administrative or bookkeeping procedure. We have, you know, I'm guessing, but $500,000, $1 million worth of equipment on the ground. I know that will be the second hearing, but the assets are on the ground and there's now no owner.
If these had been genuine documents, it would have been easy for you to produce contemporaneous material showing their existence.
For what purpose?
Well, documents tend to be produced and then circulated, for example, by email.
To who? Yeah, I understand the concept, but why would this be necessary? We have assets in the company that no longer can operate in Rwanda, so there is no owner. We had to transfer them.
Let's look at what the resolution says now. On its face, this resolution authorizes you to take any and all actions necessary to effect a sale. Yes? So on the Spalena version, take any and all action necessary to purchase. And on the other resolution, the 123, C123, on the Bayview Group version, take any actions necessary to sell. What you don't have is any actual sale agreement between the two parties, do you?
Well, I smile because, you know, you're not going to be happy, but you took all of our documents. The fact that we retained these for reasons I don't know in a different place is not our fault.
So are you suggesting that there was an agreement that it's got lost?
Well, it would have been two sentences if there was.
Well, you don't know, so you're speculating.
I don't recall one way or another. No, I can't imagine I would not have created it, because otherwise, how is it affected? This is the authorization to act on behalf of BVG. The other is the authorization to act on behalf of Spalena, and then you have a 2-sentence purchase and sale agreement. So I can't imagine that I didn't do it.
You don't know because the reality is that there was no sale and no transfer of assets, and this is another invention for the purposes of this arbitration, isn't it?
No, that's not true.
Mr. Marshall, you said these documents were kept in a different place. Where were they kept?
We had, I don't, there were, we had an office which was seized, as you recall, and we had an apartment. So sometimes I would often take documents home. This is not a document was where I was going that I would have sent to my investors. This was just an administrative housekeeping matter. So
the reality is, Mr. Marshall, we've got a very large number of documents from your side in this arbitration. You don't have difficulty getting hold of documents where they actually exist.
No.
And the reason that you haven't identified any documents showing the existence of this transfer is that you've made up what you do have for the purposes of this arbitration. Yes.
No, and it's not true. And you can't guess the number of documents there would have been because you have no idea, with all due respect. You say we have a lot of documents, and I'm glad and grateful for that. But you can't guess at how many documents there were. You're assuming that it's insignificant. And that's not a fair assumption for you to be drawing.
Let's go to C123. C-123. I'd like to now go to the second page of this document. You'll see there that there's a list of the items purportedly purchased, involving 5 truck tractors and a number of other trucks and bulldozers and other vehicles. And on the next page, if FTI could just go to the next page, a list of heavy mining equipment, including crushers and other items, and the list goes on. Now, Mr. Ehlers, as managing director of NRD, has confirmed in his witness statement that you took him out to look at BVG's Bisesero site in late 2012, and these assets were not visible there at all. And that's correct, isn't it?
No, some were there. We, in anticipation that this was a greenfield mining site, had been, when we realized we were going to be receiving the long-term concession in 2007, we started buying materials in the United States. We traveled around and bought them at numerous places because they were advantageous prices, and we orchestrated them to be shipped over there as we were building out the mines. You know, I'm sorry, I know you don't have mining experience, but you don't bring everything there and assemble it like, you know, Tinker Toys. That's not the process. You bring assets as and when you need them.
Mr. Ehlers has confirmed there were no operating vehicles and no processing facilities at Bisesero, and he's right, isn't he?
No.
The assets you've mentioned in this list did not exist at the Bisesero site at all, did
Some
they?
of them did, were present in Bisesero. As you know, when you're mining, you don't build a plant first. You provide jackhammers and you provide compressors and generators so that the artisans can generate better production than they were by hand.
So you're suggesting the jackhammers might have been there, but not the other material. Is that what you're saying?
No. I would have to go through the list and have to sit down with our logistics people to find out which ones were there and which ones were not.
Well, there's a lot of processing.
Ehlers arrived in June 2010, formed a joint venture with us a month later, saw what we had, needed some of our pieces of equipment for what he was doing, was very keen to have this cooperation agreement with the expectation that it would be a long-term joint venture. We were delighted, you know. This independent of Mr. Stark, of Mr. Ehlers, H.C. Stark.
I'm just going to stop you there, Mr. Marshall, because that's not at all an answer to my question. I want you to focus on my question.
Okay.
This material was not on site at Bisesero, was it? And PBG did not have it to sell to NRD, correct?
No. Some of it was on site, and BVG did have it available for sale to Spalena.
Now, Mr. Sindegaya was at NRD until September 2012, 9 months after the resolutions we've just been looking at. And not only was he there at NRD, he also visited the Bisesero site on several occasions. And he also says these assets were not there. And he's correct too, isn't he?
No, he's not correct either. And he was suspended for, I think, maybe 6 months of that period until the end of 2012. So he was not even in the office during that time. There were some of these materials here. Which ones? I need to get a logistics guy in to say which ones were there and which ones were not.
He confirms that none of the trucks or heavy mining equipment that are listed were there, and he's right.
No.
And perhaps more significant, he also confirms that none of these assets were transferred to NRD. And he's right about that as well, isn't he?
No,
Well, he would know, wouldn't he?
no.
Well, of course he would, because he's doing the books for this company, and he's going to know if all of this equipment has been transferred to NRD, isn't he?
No, it was transferred to Spalena, and Spalena was transferring it to NRD. What he knew when, we were very disappointed in him.
And this asset transfer never happened, and these assets were never provided to NRD, were they?
They were provided to NRD.
And this is another invention for the purposes of this arbitration, isn't it?
No, it's
And you haven't, in fact, produced any corporate documentation of either BVG or Spalena, which suggests that BVG has an interest in Spalena, have you?
which BVG. Well, I thought we had.
Well, you haven't. Now, let's come back to the US investors. You say the same US investors are behind both Spalena and BVG. Who are these investors?
Because of the death threats, I don't want to give their names.
Do you say it is you or family trusts in which you or other members of your family are beneficiaries?
I don't wish to, out of fear of safety, I'm not going to comment on that.
Well, let's look at C070. This is a letter from the Rwanda Development Board, from a lawyer, from the Registrar General there. And it says, and this is to the Mayor of the Bugesera district. And it says, reference is made to our communication of 6th of August 2012 regarding the suspension of the position of Managing Director in the above named company, and that's NRD. We have recently received legal and authenticated documentation showing that the holding company of NRD Limited, NRD Holding GmbH, is wholly owned by Spalena Company LLC, an American company incorporated in Delaware, but is in turn wholly owned by Mr. Roderick Marshall. In his capacity as, therefore, as sole shareholding of the holding company, he submitted copies of a notarized resolution. So you were telling RDB and providing them with material to show that you were the whole owner of Spalena.
No,
Well, that's what you were telling RDB, isn't it?
no,
So the US investors are you.
no,
But why were you telling RDB that?
I didn't.
Have they got it wrong, have they?
This letter is wrong.
You
And they
were
know.
that's exactly what you were telling RDB at the time, isn't it?
No,
Well, let's come on now. I'm going to come on now to the acquisition by Spalena of NRD.
I'm happy to introduce all of the investors to the arbitration panel, but I don't want their names released.
I'm going to come on to Spalena's entry into the NRD story following its acquisition in December 2010. Before I do, I just want to ask you about some of your evidence that relates to the period before December 2010, so before you got involved, Spalena got involved in buying NRD. Now, you suggest at paragraph 6 of your witness statement that between 2003 and 2007, RDB representatives urgently asked you to form a group and have a recognizable US-owned investment mining in Rwanda. Do you see that at paragraph 6?
Yes.
That's not correct, is it?
Why?
No, it's simply untrue.
No, that's true.
Can we go to
the phone calls? Lambert and his staff were calling me certainly every week.
Shall we go to R100?
I'm sorry?
Let's go to bundle R100. This is an email chain involving Ms. Moskovikova, and who I know we'll be hearing from. And can you go to the second page of this document? Ms. Moroskovikova says, here are some addresses I found on the internet. Please let me know if they're current or we need to update them. These are institutions we think the material should be sent, also probably to Williams, Alex, and some other people in Reaper. I hope you're around, or should I ask somebody in Reaper? Please let me know what you suggest. And then we go over to the next page. Mr. Mukhia responds, thanks for your email. I'll send you update email addresses tomorrow. If I have changes, you'll send the proposal with a signed transmission letter. And then he explains what you have to do underneath that with regard to the consulate. And what we can see from this thread is that it is you pitching to the government of Rwanda and not the other way around, correct? That's what was happening. You were making a pitch to the government of Rwanda and getting the right email addresses to do so, yes?
No, well, I can imagine that we were being told that this is the process, that we needed to send the documents that they had prepared jointly with us to these entities. But this is not our initiative. This is the process as it explained to us.
And can you go to bundle C138? On your side, this is a document that you rely on to demonstrate that Rwanda was soliciting investments from you. This is the material you rely on. Now, this document comes after the email we've just been looking at. Hang on one moment.
This is 2006.
Yeah, sorry, C138. I think this might be R138. If FTI could put up C138.
My apologies.
That's all right. So this is the document that your side rely on to demonstrate that Rwanda, you say, were soliciting investments from you or people connected to you. And it comes after the email we've just looked at. And in the third and fourth paragraph, what's said is this is from Rwanda, your proposition are very interesting, but for the finalization of the joint venture process in a short period, I should send an offer of your company before 30 September 2005. This includes your identification, your experience in the mining industry, your investment plan, and your action plan. In the preparation of your investment plan, take into consideration our proposition, including the terms referenced sent to you in April 2005. In other words, the investment plan should take into consideration the choice of equipment on the basis of rational methods applied in research and mining and treatment of ores. Again, quite clear that it's you who's been promoting a proposal to Rwanda, and on the Rwandan side, they're telling you which targets you need to hit. Yes?
Well, I appreciate your interpretation of it, but that's not the way the process worked.
Well, it's what's evident from the documents, isn't it?
I don't know that if it's evidence from all the documents. As I recall, Lambert communicated after this letter to us saying, yeah, that's the official process, but we need your investment. So here's how this is going to work. And it had nothing to do with this process.
Now, this is going to be a bit of a refrain, isn't it, Mr. Marshall? This idea that there are assurances from people which are not reflected in any document. Is that right?
I don't know.
Because the documents do not show any assurances of the kind that you seek to rely on. And in fact, they're inconsistent with them.
I don't know that that's going to be the case.
Let's see. Should we go to paragraph 7 of your witness statement now? You say that the most significant aspect of our solicitation was that our investment in Rwanda would be strongly supported by the government and state agencies, including guaranteed security for our future company staff and property. The RDB took me to dozens of meetings of state officials who reassured me that RDB's representations were true and correct. They convinced me that claimant's investment in Rwanda was so significant to Rwanda that the government would gratefully work to ensure our business success.
Yes.
Now, none of that is true either, is it?
All of that is true.
We've seen the documents. It was you trying to seek support from Rwandan officials for your proposals, and you received none of these assurances, did you?
I understand that those are your conclusions from those select documents, but that's not what happened.
And can we look at paragraph 8?
There were not just written communications, I think you'll appreciate, not in addition to whatever has been taken by the government out of our offices. What you're characterizing a system which was never in practice in Rwanda, never.
Well, when you just said earlier, not in the documents that, 1 moment. You say not your conclusions from those select documents. I'm just going to the documents that you have relied on in this arbitration in support of these so-called assurances.
These are the documents we have available. We're forced to rely on what we have, but it's you that took our documents.
If you look at paragraph 8, you say, I was repeatedly assured that if I invested in the concession, the government of Rwanda would assure that I would receive a long-term contract from the statutorily defined concession holder for 30 years with the possibility of an extension. I learned that all concession holders had received the same guarantee. And that's not true either, is it?
Yes, it is true.
Just give me 1 moment, Mr. Marshall.
I'm sorry?
Just give me 1 moment. I'm just trying to understand what your evidence is. Your last answer was to the effect that Rwanda had taken your documents, and that's why the material is not available. But your earlier answer, and this is at the transcript at 1915, you say, I don't know that it's in evidence from the documents. Lambert communicated after this letter saying, yes, that's the official process, but we need your investment. So is your evidence that this thing is undocumented, or that there were documents?
No, I think my memory, if my memory is correct, I was just looking at that document yesterday or the day before. Lambert says, yes, there is this process, but what you need to do is just to write the head of the privatization ministry, and the process will be finished for you.
And there are no documents suggesting any assurances given, and there were in fact no assurances given. That's correct, isn't it?
No.
Now let's go on back now to the acquisition of NRD. And one of the things you did when considering whether to acquire the company was to review the contract between Rwanda and NRD relating to the concessions, correct? That's the November. Yes, one of the things you did when you were thinking of acquiring NRD was review the contract related to the concessions. That's the November 2006 contract.
Yes.
And just to place this in time, we're talking about a November 2006 contract and then licenses. Sorry, November 2006 contract and then an acquisition by you in December 2010. Yes, 4 years later.
That's correct.
Now, we're about to look at the contract, but it's right to say, isn't it, that you had no involvement in the negotiation of that contract, because, of course, that was done at the time of the Zarnax a long time before you got involved. Yes?
Yes.
So the actual understandings of any parties to this contract at the time and the course of the negotiations is not something you can give any evidence on, correct?
Only to the extent that there's a course of dealings after the signing of the contract.
Well, again, unless it's after 2010, the end of 2010, you can't give any evidence on that either, can you?
No hearsay, that's right.
And you haven't called any witness who was involved at the time, have you?
No.
So in terms of any understandings about a guarantee of a long-term concession for NRD or anything like that, you don't know. outside the terms of the contract because you weren't there, correct?
No, I would say that the communication between us and the Zarnax and then us and Stark were several times a week. We understood what they told us.
Well, now are you going to suggest that there were communications between the Zarnax and Starks where they expressed an understanding about a long-term, about a guarantee that you've never mentioned before in your memorials or your witness statement?
I think you're a little bit confused. You know, we had all been asked to accommodate Rwanda. Mining companies, nobody, you, me, nobody would take a risk. Here is our millions of dollars of investment, and now you tell us whether we get a license. This is unprecedented. And
So
the reason is,
just drilling it down to something you can express accurate evidence on, you have no idea about any understanding on NRD's part in any period before you get involved in late 2010, do you?
all I can say is that we met as a group, and there was maybe 10 of us, as I've started to express before. All of us had the same understanding that that was our safety net for all of us. Everybody had the same, with slightly different wording in a few places, but everybody had the same concept. We're investing now because the guarantee, the representation is being made to us now. We understand that Rwanda is disorganized and needs to get their law in place and several other administrative steps, but we all expected a commercially reasonable long-term concession agreement.
You don't know what
Without exception.
You don't know what NRD expected, and you didn't yourself have any assurance of a long-term concession, did you?
We all had the same understanding of that contract, and that's what we were told it represented.
Can you go to paragraph 19 in Mr. Guattari's witness statement?
Sorry, I just want to add one thing, because otherwise Rwanda is scamming. You know, this doesn't make any sense. Please come here, invest 20 million or however much, and then we'll tell you whether you can stay. That never happens in the mining industry. These are tough companies.
What they told you,
Rwanda was an exception because of their extraordinary history, and that's why.
What they told you was come here, spend 4 years industrializing and exploring, and if on the back of that you could provide a feasibility study that is satisfactory to the government, then you can look at a long-term concession. That's what they told you, isn't it?
No, you know, everything that you just described, industrializing, exploration, this takes enormous amounts of money.
And that is why the Zarnax said they were going to put forward 39 million.
The Zarnax expected the long-term concession. They said they were going to put in 39 million. That's how much their commitment was to the future success of Rwanda.
But they knew, and you knew, that unless you could do some adequate exploration and industrialization, and on the back of that produce a feasibility report that satisfied the government, you wouldn't be getting a long-term concession.
It's a feasibility report that satisfied our investors to continue, not the Rwanda government.
Can we look at Mr. Guattari's witness statement at paragraph 19? This relates to your assertion that you were assured that if you invested in a concession, the government would ensure a long-term contract was provided.
Yep.
Mr. Guattari says, I do not believe Mr. Marshall was given any such assurance. And even if he had been, it would have been clear to him as soon as he read the concession agreement between BBG and the government of Rwanda, which he signed in 23rd March 2007, that the grant of a long-term concession was subject to certain conditions and did not contain any government guarantee. The same is true in relation to the 4-year agreement signed between NRD and the government in November 2006, although that was obviously prior to his Mr. Marshall's involvement. And that's correct, isn't it?
No.
You would have known there was no such assurance, and you would have known, you knew that in relation to Bisesero, and you would have known that when you reviewed the contract in relation to NRD.
No, and not only, we were being asked, as you use someplace else, for an indulgence. Please help Rwanda get their mining system jump started. Give assistance, because all of Rwanda mining is artisan support. Please help us. Please take that jump, and we promise you will be made whole. We promise you will not suffer. We promise that you will have a commercially reasonable long-term license agreement.
And contrary to evidence you've also given, there's no understanding in the mining community that the application for a long-term license is a mere formality, is there?
No, long-term license agreements are not a formality. They are a real negotiation prior to any works being done. No mining company, with the exception of maybe some very superficial exploratory work, is not going to spend any money at any deposit without knowing in advance that it has a long-term license concession. You can't afford to.
But on
Nobody
that,
can.
on that argument, Mr. Marshall, you would simply have a long-term license. You wouldn't have what you in fact see, which is a contract for a 5-year exploration license coupled with conditions and a requirement for a satisfactory feasibility study. It's completely different from what you say was the deal.
I'm sorry, you're going to have to rephrase
Well,
it.
on your argument, one would simply just move straight to a 30-year license, wouldn't you?
Most companies do. Everywhere else. Tanzania, Uganda, Congo, Kenya.
And in this case, what instead happens is you are given 5 years to prove yourselves before there's a long-term license being offered, correct?
No.
Now let's look, just coming back to your earlier answer about what the mining community expects. The mining community will expect that any one party's rights will depend on the terms of its contract, won't it?
I'm sorry?
The mining community would expect that any party's rights would depend on the terms of their contract.
Sure.
And amongst other things, it would depend on the mining operator fulfilling their side of the bargain in the initial period, correct?
Yes.
Now let's look at the contract itself. Go to bundle C17, C017. I should say, sorry, I said to you in one of my questions earlier, 5-year period. I meant 4-year period, just to be clear. Now, you are looking at, so this is the contract you would have reviewed as you were contemplating acquiring this company. So you would have seen from Article 1 that this was a 4-year contract, yes?
Yes.
And then in Article 2, you would have known that there are these obligations of NRD under the contract, yes?
Yes.
And you would have known that if NRD was in breach of its obligations, the contract was capable of being terminated, yes?
Yes, that's what the language says.
Yes, so you'd have known even at that point that far from being a guarantee of a long-term license, it was already conditional on whether NRD could meet its obligations, yes?
No.
Well, what else? How else would you have understood it?
This isn't the only communication. You know, they came to us and said, look, we don't have our long-term mining act in place. So we're being instructed that we're going to do these short-term arrangements so that we can.
Are you suggesting that the contract doesn't represent, as you understood it, the rights of NRD?
No, I would say that the rights of NRD are greater than in the agreement. Representations were made to us. If you invest money and you do things that we will be able to work you through in close cooperation with the government, then that's just an administrative act when you get the written long-term license agreement.
Well, you say representations made to us. They weren't made to you because this is NRD's contract and you weren't even there.
All the contracts are almost the same. All of us had the same experience, same
But
presentation.
you don't know what representations were made to anyone at NRD when this contract was entered into because you weren't there. Correct?
Well, it is true that I wasn't there. And if all those conclusions are necessarily from the fact that I was not there in person, I was with them every day of every shareholder mining investment forum meeting. I knew them. We all shared agreements. I'd seen this agreement before. We are all, as far as we knew, in the same boat.
And when you bought into this company, the rights and obligations that NRD had were reflected in this contract. Yes, that's what you would have thought at the time.
I understood this contract to be part of a larger relationship. And I knew that Rwanda was good for its word. If somebody comes and invests $10 million, whatever number it is, 20 million, 30 million, they're not going to just throw them out. They don't behave that way. They will talk to you till you're blue in the face about the fact that that's the way they work. They have to get people who understand their situation, their desperation, their trying to pull a country together after a war.
Just to be clear, is it your evidence that you knew at the time that this guarantee of a long-term license was not in the contract?
It's not in this contract document, but we understood it to be in other documents.
So you knew at the time that the contract document that
we understood they just meant it. I understand they don't use the word guarantee here, but we understood the meaning of this, the way it was going to be interpreted.
Well, again, Mr. Marshall, you are a lawyer and a transactional lawyer. You know very well that parties' rights are reflected in the contracts that they have, and you knew very well that this did not contain the assurance or guarantee that you now say existed.
Well, two things. One, and I know you and I will be in an argument about it.
Can I just interrupt a moment? It may be that we're going to be cut off. We're just trying to deal with this. You've got a notice saying we're going to be cut off in 1 minute.
Right.
Yeah.
But if you freeze, then I will stop.
If in Article 4, we were told that gave us an automatic right to a commercially reasonable long-term agreement.
You don't want to click on
I
OK.
think, stop, Mr. Marshall. I think the tribunal have been cut off. And
Press any button except the power button.
Yes. I'll just wait until this is sorted out.
Right, we've got a phone number for Alex.
Yeah, I'm here, but is this a Zoom?
Email.
Is it a Zoom error or?
Tomorrow morning.
Doesn't appear to be. It may be their system there.
Calling me is not going to help.
I'll reach out to the IT folks.
Please do.
Cursor is not it's not responsive to the cursor on the laptop, so it might be worth using a different one. I can arrive early tomorrow.
Can they not hear us? I guess not.
I'm also have to send an email.
Say, don't go home.
Yeah. I know, well, everything's
Should I mute them, Alex?
Okay.
Case?
If there's somebody there, yeah.
Yes, please.
I'm going to mute them. Just
Or perhaps,
What I'm
I'm also happy to-
wondering, just while the tribunal's out, is we're about 25 minutes before time, whether we should just simply break and try and find this 25 minutes in some other part in the rest of the week.
I can definitely relay that request. I know that the president had some administrative points he wanted to raise with the parties, and we do have a full schedule, so there's also the difficulty in finding the 25 minutes. Let me see what we can do. Hold on, please.
can you hear us at the IDRC? I guess not still. Hold on. Alex, I reached out to the IT folks there.
So I think, Mr. Cowley, we can hear each other.
Hello, this is Mr. Cowley. Was I asked a question?
Yeah, but
No, don't worry, it was me.
They can see and hear us.
I'm sorry, what was the question?
I can't hear you, but I can see you speaking.
Oh, really?
Don't worry, Mr. Cowley. I was just trying to understand who can hear whom. I think we can hear each other, but the tribunal, we can
yeah.
hear the
Mr.
tribunal,
Hill,
but they
can you
can't
hear
hear
what
us.
I'm saying?
I'm going to
I
take
can
a
now.
2-minute opportunity. I'm going to take a 2-minute
Can you hear what
opportunity
I'm
for a
saying?
restroom break if people don't mind. So I'm going to turn off my camera.
No, Mr. Cowley, I think the tribunal are now back on. Mr. President, I just heard you, I think.
What is
Yeah, we can hear you.
got an email from Alex.
They can't hear us.
They can't hear us, I think.
That's right.
Right.
That's not the problem. They can't hear us.
Okay.
Does
I thought
anybody
he
have an
just-
objection to me taking a 2-minute break?
Oh,
I don't.
by no means, no means. I mean, not that I can rule on objections, but please do take the break.
Can you hear me, Alex?
Yes, we can hear you fine. Can you
I
hear
can't
us?
hear you. Raise your hand if you can hear me. Right, you can hear me. What I suggest we do is adjourn until tomorrow morning. We've only got
Okay.
20 minutes to go. All right, and we must try and sort this out.
Could I just ask, I know the president can't hear me.
I can't hear anything you're saying. I can see you, but you can obviously hear me. So the first thing I'm going to say is that tomorrow, now I've lost sight of you.
Oh,
I don't know whether you can even hear me. In case, can you hear me, Alex?
Yes.
You can hear me, right? Well, tomorrow the timetable will be changed in as much as we will have a 30-minute break at the first break and a 30-minute break at the second break. The second request, and I don't know whether this will get to them, is that the tribunal would like to have delivered to the hearing room hard copies of the transcripts printed on both sides of each page. Is that possible?
yeah.
I can't hear you anyway, but
yes,
do you think
it's
that can
possible.
be done? Okay.
Yeah.
Well, then I think it remains for us to say farewell until tomorrow morning. We
Yes.
made good progress, I think.
The tribunal hasn't given the witness warning. Mr. Harrison, you understand the witness warning about Mr. Marshall not speaking in between the breaks. I'm sure the president would have given it were he here, but can I rely on you, Mr. Cowley, to give the warning to the witness?
Mr. Cowley he still stepped out. He's
Well,
coming
if
back
you
in
explain what I
now.
just said to Mr. Cowley, I'm sure he will give the warning to the witness.
He
Fine.
just came back in, but
All right. Farewell until
All right.
tomorrow.
I apologize for being out.
Yes, Mr. Cowley, where we've got to, the tribunal's given some directions that can be explained by Mr. Harrison. They can't hear us. They weren't able to give the witness warning, so I wonder if you could give the witness
What?
warning to Mr. Marshall,
Send a summary.
just about not speaking to anyone about his evidence while he's in giving evidence.
I'm sorry. I didn't hear everything that you said. Are you saying the tribunal wants to give this instruction? Or are you asking?
I'm asking you because we can't communicate with the tribunal, so I'm asking you, unless you disagree, to make sure that Mr. Marshall understands he's not allowed to speak with anyone about his evidence while he's giving it in the breaks.
I have no problem, but if you're putting on me the responsibility, I want to just agree that the language I read to him is exactly the language as I should be saying it. So if I can ask of you, because this is sort of a bit of a curveball to me, just tell me what provision
Yes,
of the.
well,
of
I will
the-
say it. It's simply that while he's giving evidence, as he is now, when he has breaks and overnight breaks, he shouldn't speak with anyone, his lawyers or anyone else, about his evidence or about the case. Obviously, doesn't prevent him speaking about other things, but he shouldn't be speaking about the case or his evidence to anyone.
That's fine. I simply asked, is there a procedural order section that should be read to him? I'll make sure he reads it. And
I don't think I'm not aware of.
No, it's just I don't believe in our procedural orders. We have that, but it is a customary undertaking at ICSID, given that Mr. Marshall is basically still in the witness chair, but will be obviously not physically in it until tomorrow morning or tomorrow morning. So just the understanding.
So you're done. You're saying you stated the warning, nothing else to be read or shown to him.
Mr. Marshall obviously understands it because he's listening. That's right. Yes, Mr. Marshall.
Yes, I understand what you're saying.
Thank you.
And this would apply to all witnesses, of course, through the hearing.
Yeah.
Okay. Mr. Kelly, while you were having a break, indisposed comfort break, this is not resolvable right now, the technical issue. So the president had suggested to adjourn for the night. The parties should please produce an agreed schedule that for tomorrow that shows the first and second breaks at 30 minutes. And we will arrange upon the tribunal's request for hard copy transcripts to be delivered to the tribunal as they requested. And that's what you missed.
Thank you.
Sure. We'll see everybody tomorrow.